Lord, may I have leave to?
There is not the mentioning there.
No, for leave, for granting, for filing the appeal without certified copy. My order has been passed on 11th March.
What is the urgency?
Urgency is that the notice has been given to remove my shop. The order was passed after hearing the order was passed for appearing the matter in the month of December, and no bar to demolish my or the shop room. That's the whole trouble, my lord. Much obliged.
Lordship, may I to lift him as Lordship, remember on last Thursday, Lordship, had one assigned matter
Yes,
in
yes.
original side matter. Then matter I inform you, Lordship,
Original side.
yes, man, original side.
Mr.
Assigned matter.
Kollan Bandyopadhyay.
Someone reading me.
Yes.
That time I inform you, Lordship, I send a letter for assignment, some main appeal, man. And now, man, main appeal, batch of appeal assigned before your Lordship.
How many matters are there?
There are, man, 13.
So who are the counsels appearing for the writ petitioners? Have you given notice?
All matter, Mr. Sahara appeal.
You have given notice to Mr. Shahara?
No, I just now today.
So very good. Today we are on Tuesday. Your matter will be, I think, on 28th.
28th, man.
Very good. On you give a notice to Mr. Shahara intimating it has been assigned that you will mention, then we will consider. All right. Any if there is any other counsel for the writ petitioners,
No,
please
all matter, Mr. Sahara appeal.
very good. Remind us on Thursday upon giving no prior notice that you will mention on Thursday. Yes.
May I permitted to mention one matter, my lord?
Today is not the mentioning day, madam. See the list Monday and Thursday. Yes.
My lord, with the leave of my lord Justice Mitro, my lord, I'm mentioning this matter which your lordship had made part heard, sitting with Justice Partho Sharthi Chatterjee. This is with respect to that Salt Lake
That Salt
property.
Lake property.
My lord had pleased.
When it was made returnable.
Today, my lord had made it returnable only on the limited point of taking
Okay,
instruction.
very
Whether
good. I shall be sitting with Justice Chatterjee. On that day, it will appear. Please
May I
keep
just-
a watch on the list.
May I just hand up?
Most probably this week or next week. Just ওটা একটু দিয়ে এগুলো না একটু ইয়ে করে নিও কোনগুলো কালকে লিস্ট একটা ছিল। Yes.
I'm grateful.
Item number 1. কি আমরা জমা দিইনি বলেছিলেন?
কিছু না, কালকে পার্থদা বলেছিলেন ইনস্ট্রাকশন এবং আমরা উইথড্র করা
না কি এটা জমা দিইনি নাকি বলেছিলেন?
জমা ইয়ে
Yes, Mr. Dhar.
Well, yesterday I could not appear. I was on my legs.
Roy
Mr.
appeared.
Rai appeared.
We
Did
were not
appear.
inclined to interfere, so we asked him that whether he will withdraw the same or we will pass orders. So then he said that let me take instruction and come back tomorrow.
Perhaps the state has submitted that we did not deposit certain fee or something like that.
No, no.
Oh.
They didn't say anything. Upon perusal of the order, we thought it fit not to interfere. So we were dictating the order, but at that time we asked Mr. Roy that whether he is inclined to withdraw it or not. You
Well,
talk with Mr. Roy.
Well, Mr. Rai is on his legs. Make it pass over, then
we will take it up at 12:45. We have a separate bench at 1 o'clock.
my lord.
So you get that instruction and
Well,
either you appeared or you ask your
well,
junior to
my lord.
12:45. Yes.
But in this matter, I'm paying on behalf of Mr. Samanta on short password. He is coming, my lord.
Many times we will adjourn.
He is ill on the ground, my lord, short password. He is coming, my lord.
You are
I'm
there.
for the state this one.
Yeah.
For restoration,
4,000 delay.
yes, my lord.
You have used opposition.
Yes, my lord.
They have used it.
Yes, reply. Yes, my lord.
Then
So, my lord, earlier the lodge is given direction to give supply of the Supreme Court's order, COVID period delay condonation that on that down, my lord, adjourn this matter. My lord, today ready, but on that only for my friends on short passover. In the meantime, my lord, only short passover. And in the meantime, see, coming, my lord.
pass over.
I am grateful, my lord.
Listen, it will appear tomorrow. Tomorrow ask him to appear.
Yes, my lord.
Any problem tomorrow?
Day after tomorrow. Tomorrow I have a fixed matter at 10:30.
All right,
No,
day
day after
after tomorrow.
Yes,
Yeah.
my lord. Yes.
You- the- dismiss for default to teacher or whatever. Two weeks.
No, I am for the petitioner in this matter.
My lord, I am for the legal heirs of the private respondent against which they have filed a substitution application.
No,
I am for the legal heirs of private respondent.
Can one is the substitution?
substitution petition. My lord. I am led by Mr. Bose in this matter, Mr. Moinal.
And my lord, in addition to that, my lord, challenging the order of the learned tribunal, I am also filing one writ petition today, my lord. I am praying that both the writ petitions may be taken up together next week, my lord. I will provide the number today itself in course of the day.
It is substitution application be allowed.
Yes. No, I have no difficulty.
We will allow on that day. Oh, who has expired?
My lord,
Sole private respondent, my lord.
Sole private respondent.
Point number 6.
This one was 6 months.
Which paragraph you have given the names?
দিয়ে তো ছিল আমাদেরকে তোরা কোথায় পেয়েছিস?
Paragraph number 3, my lord.
Huh?
Paragraph number 3, my lord.
2 and 3.
2 and 3.
Paragraph number 3.
তিনজনকে
তিনজন তো দুটো ডটার আর এর একটা ছেলে আর মেয়ে ওয়াইফ 4 জন।
ওয়াইফ, তারপরে ছেলে, এই ছেলে হবে বি মানিক সাউ।
হ্যাঁ, মানিক সাউ
মানিক সাউর ছেলে।
ছেলে দিয়ে
তারপর বি বি সি হয়ে যাবে ছবির লাস্টে ছায়া। তো ঠিক আছে।
Paragraph
5/2/2024 জানিয়েছে 2/12/2024 মারা গেছে।
একবার
হ্যাঁ?
একবার
ওকে 10 মাস আগে জানিয়ে দিয়েছে ওর বাবা মারা যাচ্ছে।
25-এ জানিয়েছে।
ধরেন 24 এর জায়গায় 24 কি?
So this is an application. The present application being Can 1 is an application for substitution of the heirs of the payments against honor the instrument number 6 ও
5/2/24 জানাচ্ছে মারা গেছে 1/12/24।
ভুল লিখেছে। What you have written in paragraph 12?
No,
Paragraph 2, 5/2/2024.
5/2/2025, my lord.
Instead of 2025, he has written 24.
Kindly give me leave, my lord, to correct.
My brother has rightly pointed out.
And I also showed him.
যা হোক একটা লিখে দিলেই হলো না,
Kindly give me leave,
বড় হয়ে গেছো। Don't make this sort of mistake.
my lord.
It sends a bad impression. Yes, your other side says that he has also filed a writ petition. So he is requesting for keeping both the matters on Monday. In the meantime, we are allowing the substitution.
In spite of paragraph 2, we allow it.
Have a look at paragraph 2. I'm sure you have not seen.
Sent a letter dated 5th February 2024 to the petitioner, whereupon it will be the sole respondent died on 2nd December 2024. He wrote a letter on 5th February, he died on 2nd December. He told that after
No,
it should be 2025.
typographical.
And Ashok,
Must be 2nd of
No,
the
this one
present
20. The letter should be 25.
there, it can happen.
Right. Yeah. Possible. With him around, everything is possible. With you around, also everything is possible.
Ashwini Shah was the petitioner before original applicant.
Original applicant. Yeah.
No.
Original applicant before the BLR. From the proceedings arises out of
Before
the
the tribunal.
original proceeding was initiated by him before the BLR. Then appeal under 54, then tribunal, then High Court.
Tribunal is the petitioner.
Tribunal is the
Is the petitioner before your lordship is the
I went before the tribunal.
The impugned order of the tribunal is dated.
9/12.
So
November.
Ashwini Shah could not have been the petitioner. He died on 1st.
No, Oshini, I was the petitioner before the tribunal. He was the original petitioner before the Block Land and Land Reforms Officer.
So he was the sole private respondent in the original application.
Absolutely.
This is an app. The present application being such as substitution of the heirs of the sole private respondent, namely Ashwini Kumar Shah. Mr. Bose, learned senior advocate appearing for the writ petitioner hearing. Submits. But so he expired prior to the original application.
being heard. Yes.
তাহলে তো 9th December was the disposal.
Not disposal. The date status quo order was passed and next date has been fixed. Ex parte. My lord, may I say that the writ petitioner and the private respondent both are neighbors. It is on 1st of December when died, they cannot take steps to appoint an advocate and they were very much aware. Instead of that, they moved that application without making any substitution application before the tribunal.
Then Mr. Bose it
5th of
becomes
February আমাদেরকে জানিয়েছে।
had he expired subsequent to that.
Subsequently, my lord,
Then
my knowledge is the letter of 5th February 2025. This letter, if your lordship will see,
The knowledge will not rectify the fact an order is being passed against a dead person.
no, but the question is that, my lord, the issue would be, but I was unaware at the time when the proceeding was initiated by me, whether it was a dead person or not. My lord, today I know he's a dead person. Now, my lord, it goes back to the time when I initiated the proceeding and the order was passed, it was against a dead person. So the fact that, my lord, this has to be recorded in the present writ petition, because that's my knowledge. But if I am unaware of the death, that does not.
আমার তো knowledge নেই, আমার
So then the order itself impugned here
No, I'll
becomes
tell you.
ineffective.
My lord, subject to
order
correction, my
against
lord,
the
if
dead
I am unaware of the death, so then the order does not become a nullity. If I am aware,
no late.
my lord, this is,
Mr. Bose,
My
if you are unaware,
Yes.
the person is dead and an order is made against him, or a
Yes.
decree is passed
my
against him.
lord,
Because you're unaware, the decree becomes a valid decree
No,
passed
it
against the
doesn't,
dead person.
it doesn't,
Then what are you
it
saying?
doesn't, my lord, it doesn't become a valid, so it doesn't also become a nullity because, so, my lord, I will substitute the legal as.
No, but the legal heirs should have got an opportunity of being heard.
Yes.
Before the order was made,
No,
because on the date of the order, there was nobody representing.
so he ought to have been represented only if I had knowledge of his death, I could have served upon the legal heirs. But your lordship will kindly contemplate a situation here. It is arising out of an original proceeding. This was in the nature of an appeal when we went before the LRTT. Now, we had no knowledge prior from the initial proceeding before the
Date of hearing.
the date of hearing was
9th of December
9th of December 2024.
না
And
নেক্সট
he expired on 1st
1st of
December.
December.
Yes.
My lord,
Did anybody represent him before the tribunal? Did you appear?
No. Means because the bereavement, they cannot take steps to appoint any advocate. It is my understand. It is my instruction. They cannot appoint at that point. And both of them are neighbors within 50 meters. I have the photograph of the.
So he was served, he chose not to appear or inform the tribunal that the respondent or the private respondent in the appeal before the tribunal is no more.
This is a good ground.
Suppose you have to go back to the tribunal, so make the substitution and pray for a fresh order.
Then this order has to be set aside.
This is a
if you're,
nullity.
there's a nullity, lordship will then it's a nullity. So if it has been passed, well, not kindly appreciate one thing. If it has been passed, if your lordship is of the
No,
view
it
that
is a technicality.
Yes.
It has to be resolved because in other matters we have granted leave to appeal, but here in that situation won't arise because he is the respondent.
he is a respondent.
Please apply your mind. Come
Let
back on
me very
Next
very-
Monday, my lord.
give the number of your.
I will, in course of the day, by noon, I am giving.
It will be next Tuesday. Yes.
Next Tuesday.
next
Grateful.
Tuesday.
Mr. Siddiqui, you also check.
My lord, instead of next Tuesday, my lord, would it be a lordship pleasure to keep it on Wednesday?
You can hand over that to us.
No, this is a 3-year-old.
Now we will estimate that what will be the wrong committed to you if you fix it.
But instead of Tuesday, I was respectfully submitting if it could be on any other day, my lord, Wednesday, Thursday, any day convenient to your lordship. My lord.
Thursday.
Grateful.
Grateful.
Yes.
Judge. iPad to the iPad to the.
Exactly.
তুমি কার হয়ে সপ্তাহান্ত না? তোর কার হয়ে?
We respect that right of order.
মালমটা কি না কাজটা?
Yes, করো।
হ্যাঁ, Thursday week.
Thursday week, no? Next Thursday, 26.
Next Thursday মানে
হ্যাঁ?
Thursday week কিন্তু।
না, I have. Where is the rest?
27
Date বলে দিচ্ছে তো আবার কি আছে?
হ্যাঁ?
দিয়েছি আমার বাবা কি অপারেশন চলে আসবে তো।
Blood TT করতে হবে।
Take steps.
Yeah, got it.
The tribunal is doing this.
আমরা কত? Respond number 3, না? এটা কি আর কি হচ্ছে? এটা কি হ্যাঁ? এটা কি?
Yes.
Hey, what Mr. Moinak Bose wants? I should leave the professor.
My lord, when,
Yes,
my lord, I'll tell you, lordship, my lord, this is the anguish to the client. When you suffer in a situation like this,
In all
my lord,
matters,
he
client's
says that
anguish
all
is suffer
documents should be annexed. Now, there can be no more suffering than this. This is extreme suffering. My lord,
now shifted to
yes.
My lord,
ছোট নাকি?
না, ছোট না actually.
কি?
Mr. Basu, you are appearing for.
Respond number 3.
Oh, achha. What is the original application dismissed?
No, my lord. Your lordship will see the order under challenge is at 1016. I'll just give your lordship will kindly give me 2 minutes. I'll just indicate, my lord, the brief background. My lord, this relates to a property on Eastern Metropolitan Bypass near the Topshia crossing. Now, my lord, I am the owner of 2/3 of this property. My lord, in the year that the conveyance was executed in my favor in the year 2006. No dispute so far as that is concerned. My lord, in 2012, my lord, the private respondent number 3, whom Mr. Basu represents, filed an application before the Thika controller, and by an ex parte order, he was declared as a Thika tenant in 2012. I was unaware of this fact till 2022. On being aware, I applied for recalling of this order. No orders passed, no effective orders passed. I challenge the proceeding before the LRTT. LRTT also, my lord, passes an order against which I am aggrieved and I come before this honorable court. This honorable court passes an interim order and the matter is sent back to the tribunal. Then the tribunal disposes of the appeal and remands the matter back before the Thika controller to decide the issue afresh, whether he's a Thika controller or not. So, my lord, the Thika controller is now, my lord, exercised that authority and my lord has come to a conclusion after reports and after hearing the parties, after elaborate hearing, extensive hearing, he has come to the conclusion that this is not a Thika property, this is not a Thika land, and the third respondent is not a Thika tenant. Against which Mr. Basu's client has filed an appeal before the tribunal. In that appeal, my lord, an interim order is passed, which is impugned before your lordships. But kindly take under this factual background, my lord, kindly take the order at page 1016.
Interim order not to disposes.
No, not just disposes. He has come to certain conclusions which renders the, my lord, his appeal is allowed, effectively allowed. And my lord, the order of the Thika controller is, my lord, in substance set aside. My lord, he says, my lord, I'll tell you, lordship, the previous order of 2012, he says that the LRTT, while remanding the matter back, did not set aside the order of 2012 of the Thika controller. Since the 2012 order was not set aside by the, so that remained. So when the matter went back on remand, the Thika controller was effectively exercising a review jurisdiction. So he did not have the authority to review its previous order of 2012. And as such, the finding of the Thika controller in 2024 is a nullity. So he does not, my lord, he does not examine the fact that the order of the LRTT was accepted by the parties participated in the proceedings, and after participating in the proceeding, this is an order on adjudication, final order of adjudication. So now, my lord, there are certain findings. I wish to draw your lordship's attention to some of the findings in the impugned order.
Matter is made returnable on 9th of June.
Yes.
And there is an order of status quo till that date.
Right.
So how you are aggrieved by that? You will
Kindly look at my, if these observations, these my lord, findings are not set aside, what remains? No, this is the final. I could have said prima facie, he would have said. Kindly have a look at the findings. Kindly clarify that, I'll go back. But kindly have a look at this findings. But kindly come to internal page 3 of the order. Internal page 3, second paragraph. There's a sentence starting, perused with the record meticulously. Perused also the order of this tribunal dated 15th of May 2024. This was the order of remand. And by this order, the Honorable First Bench of this tribunal did not quash the earlier order of the Thika controller of 9th March 2012. On perusal of the order of the Thika controller of 2012, we find that the petitioner was the present OA was declared a Thika tenant with regard to the subject premises situated at such and such, and the land in question was declared a Thika land. The Thika controller, Kolkata, after perusing the rent receipt and other relevant documents and thereafter in compliance of the order of the tribunal, dated 15th May 2024, reopened the case, heard the necessary parties afresh, and passed an order of 24th of September 2024, and came to the conclusion that the subject premises mentioned earlier will not come under the purview of the West Bengal Thika Tenancy Acquisition and Regulation Act of 2001. and further opined that the petitioner of the present OA, which is Mr. Basu's client, Uttam Kumar Das, is not a Thika tenant and the subject land is not the Thika land. The same authority has passed two contradictory orders over the same subject property and with respect to the same parties. There is no denying the fact that the Thika controller Kolkata is a quasi-judicial authority, and for that reason, he is not empowered to review his own order, which was passed earlier on 9th March 2012. Honorable First Court of this tribunal, while passing the order over the earlier OA, did not quash the earlier order of the Thika controller. Then, my lord, that by the Thika controller is still in force and it has not been quashed by any higher forum. Latter order passed by the Thika controller Kolkata over the same property being bereft of merit. On the facts and circumstances of the case, the prima facie case is clearly in favor of the applicant. No, this observation, no, but kindly see, he says that bereft of merit. Then he says that he does not have a review jurisdiction. He is not empowered with the review jurisdiction. You decide it while you're hearing the appeal. So prima facie case is not going into that whether he is in possession or whether he is entitled to an interim order of status quo. Those would be consideration in my respectful submission so far as the prima facie case is concerned.
Was the order of the tribunal when it was remanded?
Order of the tribunal remanded. 228. Well, that your lordship will find possibly at the second volume. 228. আমি আগে দেখি তো আমি বলবো the situation will be fait accompli. He will say the same thing at the final hearing. Well, kindly take page 228.
We will clarify, Mr. Bose,
My lord.
that the observations made are for the purpose of granting the interim order in favor of Mr. Basu. And the matter has been kept pending, kept for final hearing on 9th of June. For arriving at a prima facie satisfaction, the tribunal said something.
No, my lord,
so we will restrict it. That is the clear observation of the tribunal that in the backdrop of these facts, we are prima facie of the opinion that there should be an interim order because the balance of convenience.
I am not on that interim order aspect at all. I am not aggrieved by the interim order aspect.
So we will say, we will clarify that is your objection. We will say that is a prima facie finding for the purpose of interim order and he will decide the main matter without being influenced by the observations made here.
So, my lord, with respect, my lord, this prima facie finding, whether it has review jurisdiction or whether the tribunal or the
that is a strong
Thika controller
that you have
had was bereft of merit or not, whether the
usually subject to what Mr. Basu says, when we remand, we usually say that the order is quashed.
If it is remand.
If it is remand.
Yes.
It's a reconsideration.
I will take 2 minutes. 2 minutes time I will take.
So you participate in the proceeding of reconsideration. The
228 by which it was sent.
No, it was this order was passed on my application.
So it is a represent, since this is a representation.
Yes, my lord.
We dispose of directing to dispose of the as if that representation was not finally considered.
Right. Now, if your lordship will kindly look at the previous paragraphs, the respective submissions of the parties.
Please, Mr. Bose, comes to the next paragraph. Since this is a representation alleging inaction on the score of violation of natural justice,
My lord.
if an opportunity of hearing is given, that will subserve the purpose of justice. So they gave you an opportunity of hearing, came to an identity.
Came to a finding.
Contrary to the finding. Again, finding এটা টিকা। এবার হিয়ারিং করে বললো না এটা টিকা না। So contrary finding.
So previous finding had no reasons.
So the previous order of 9th of March 2012 was a declaration that Mr. Basu was a Thika.
Yes.
And
No finding, no objection, nothing. He has come to a finding. So now, based on this order,
now it is said that he is not a Thika.
no. And it first comes to the conclusion that this is not a Thika land. It did not vest. So consequentially, Mr. Basu's client is not a Thika tenant. So this is a order.
No, Mr. Bose, then do you want us to go into the order at page 228 and give an interpretation of the same? That will be prejudicial to you.
No, what I'm respectfully.
If we discuss that,
right.
As my brother points out, that whether there is a dispute whether it is a remand or a reconsideration.
My lord.
So if we dwell into that issue, that may prejudice you at the time of final hearing.
So, my lord, it could prejudice either parties. It could prejudice me. If your lordship holds it against me, it will prejudice me. Either way, it might prejudice Mr. Basu's client as well.
Question is whether we shall go into that
Correct.
issue when
So,
the matter is fixed on 9 June.
All I am saying, my lord, let the tribunal go into this issue. My lord, if you have at the interim stage, if you've already, my lord, prima facie view is one view. My lord, prima facie view may be on facts. But here, my lord, if your lordship will see, in the impugned order, he has already held that the order under challenge before the tribunal is itself bereft of any merit. Well, that though in the immediately next sentence, like Justice Mitra points out, that there is a recording, it's a prima facie finding. Well, that is possibly the usual rhetoric orders which are passed that I prima facie find, but the previous paragraph, well, effectively, he has come to a conclusion that the Thika controller, being a quasi-judicial authority, does not have review power.
Same beauty observed. Consider right and forced to come to the same finding and the hearing is redundant. Hearing না দিয়ে যে ফাইন্ডিংটা এলাম আমাকে হিয়ারিং দিয়েও সেই ফাইন্ডিং এ আসতে হবে এটা তো হতে পারে that can't be the order of the higher court বা এখানে এলাম তাহলে হিয়ারিং এর অর্থটা কি reason to believe I was wrong I rectify my upon there
সেটা তো তাতে কিছু অ্যারাইভই করেন বিষয়টা রেকর্ড করে রিপোর্ট
rectify করেছি হিয়ারিংটা দাও দিয়ে
Liquor control ইস্যুটা
হিয়ারিং এটা দেখা কি করছে না এটা টিকা লাইন একটু আগে বলেছি ঠিক আছে বলুন না এটা টিকা লাইন নয় কনসিকুয়েন্স তো
if your lordship will see this two sentence, but there is no denying of the fact that the Thika controller Kolkata is a quasi-judicial authority, and for that reason he is not empowered to review his own order which was passed earlier on 9th March 2012. This is one specific finding. But I am reading from page
Internal page?
10, internal page 3.
Yes. Is a quasi-judicial.
Yeah, but the last about from the bottom of the third internal page 3, about 6 lines from the bottom, there is no denying of the fact. This sentence, there is no denying of the fact. 6th sentence from the bottom of internal page 3. See, lordship found that. That sentence, and immediately thereafter at internal page 4, which is a continuation of the previous sentence. It's a longish sentence which ends with being bereft of merit. Now, this was also an issue before the Thika controller, raised by none other than Mr. Basu's client. And the Thika controller has decided this point. So this has to be a ground in appeal, because it is their appeal, so he has to decide it. So what I was respectfully submitting, my lord, let these two findings be expunged and he decides the appeal.
Mr. Bose, the court observes that did not quash the earlier order.
Yes.
This is a fact.
It is a fact. It is a fact. Now, what will be
Then
the
when it
legal
was-
implication of that?
No, when it was relegated to the authority with this finding,
Yes.
that the order has not been quashed, you ought to have told this to the Thika controller. Then what is the purpose of reconsideration? If you
I
come
did. And that is the Thika controller has come to a specific finding on that. At page 244, a part of the Thika controller's order.
এত ডকুমেন্ট ঘেটে বলে এখানেই ডিসমিস 500 পাতার একটা দিয়ে ফেলেছে 244.
Yes, my lord.
Yes.
My lord, kindly take about the second last paragraph from the bottom. Under the stated circumstances, I cannot consider. This is the submission. I cannot consider it a Thika tendency. Then, lastly, I am not in agreement with the learned advocate Mr. Das that I cannot change the earlier order of the then Thika controller of such and such of the Honorable LRTT directed me to dispose of the representation of such and such, subject to my authority vested under law, and the law does not empower the controller to review his own order. The representation of such and such is against the order of the controller dated 2012. The Honorable LRTT is a forum where the order of the controller can be challenged. When such representation is sent to the controller with a direction to dispose of the same, it is implied that the Honorable LRTT desires that such representation is disposed of by subserving the purpose of justice. While taking into account the grievance of the petitioner as ordered, I have no option but to relook into the case. Hence, and my lord, before this, the discussions are there. Why? Why he relooked? Well, at least 10 pages of discussions are there of the order of the LRTT. I am not saying that this cannot be a ground by them before the LRTT. Of course, it would be a ground. But at the interim stage, while passing an order of status quo, these two findings is like a fait accompli to the appeal. It's a premeditated situation. Going back would be an exercise in futility. We will pass the same order by holding that same ground. None other grounds will not even be necessary to consider. So my respectful submission before your lordship is, lordship will kindly expunge these two findings of the tribunal and let the tribunal decide it at the time of hearing of the appeal.
Yes, Mr. Austin.
Lord, something has been said in aid of the relief granted in this. Kindly, for the time being, kindly exclude those portions. So-called finding prima facie or final. If it is erased from this order, your lordship immediately set it aside. There is no reason how a order has been passed. Am I clear to my lord? If your lordship erased those part of the finding of the learned tribunal,
That is why we will say that finding is
if
redundant.
those are erased from this order, immediately my rule set it aside. If we move this without this finding and reach to a conclusion that prima facie I am satisfied and granting an interim order, my rule is set aside. There is no reason at all. Court, while passing an order, has to come to a prima facie finding while passing an interim order. He has done that. And now, my lord, I am little giving instance what wrong he has committed. This is well accepted principle. Forum is the creature of a statute.
Yeah.
Am I clear to my lord? No one can create forum. Mother also cannot create any forum. If it is under a statute, well, kindly take trouble to see Secret Tenancy Act. It's a copy then,
Section 11.
Prima facie is not having very defined.
Kindly come to.
No, Mr. Basu, the order which we are intending to pass.
Yes, I have understood, my lord. You always said it prima facie. I say it is prima facie.
So we need
But
not go into
what I am submitting, my lord, court has not come to a wrong conclusion. At least prima facie.
You're asking us to get into the merit. If it's wrong or right, if we are deciding that.
I am not
then we are
asking, my
getting
lord,
into the merit.
when your lordship is holding this is a prima facie, even for the prima facie he has objection. The court has said that is a prima facie finding.
What he has an objection to, Mr. Basu, what we have understood of Mr. Bose is that the finding that this appeal or this is bereft of any merit.
That is, I'll come to the next. My lord has pointed out.
How is that a prima facie? If you're saying the appeal is bereft of merit, then what remains? That's his apprehension. What remains at
This
the
is
finding?
the nature of writing.
Okay, so
I am a bad English writer. I will write in this manner.
don't write-
Otherwise,
you can't impinge on person's right due to your lack
no, not impressed at all. He said, I think prima facie court has bereft of power. And that's why you want to show to lordship he is not wrong. Prima facie, I am not saying that is a final. If it is final, nothing remains to be decided.
I'm deciding, I'm making a comment on the appeal.
Yes, this has to do. My lord, I repeat, my lord, if those findings are not there, the order is without any reason.
No. Bereft of appeal, bereft of merit is not there. There's no interim order. What are you saying?
Kindly erase those part. There is no finding of the court.
So, Mr. Basu, we need not go into that because you are also agree.
I say this is prima facie.
Ashok, the present.
I say court. The remand I have bought, my lord, kindly refresh your lordship memory, order 41, rule 23. What is remand? Is it remand?
So that we've said. Moreover, I saw page 230, it says representative.
This is not a remand.
The present
Mr. Sufi Kamal, who is appearing for the petitioner, he is engaged in another court. Appearing for the petitioner, he is engaged in court number 17. I am praying for short passover.
Come tomorrow then.
My lord, I'm for the private respondents.
State.
My lord.
What, expeditious disposal?
Expeditious disposal, my lord.
Oh, achha. When is the date fixed?
My lord, next date has been fixed, my lord, in 25th of November 2020. My lord, 27th of November 2025.
Matter, madam.
No matter, no Lordship, I am not breaking
You are
this
his
matter.
junior.
Yes, Lordship.
The only prayer is expeditious
My lord, before
disposal
the
of-
tribunal, I am the applicant, my lord. But I'm, my lord,
Lordship,
virtually
kindly take
supporting
it
the
at
prayer.
12:30 p.m.
The only prayer is expeditious disposal of the original application. It was taken up on 8th of January and it has been fixed on 27th of November.
We can pass it over or keep it tomorrow.
Can you keep
We
it
find
tomorrow?
that-
my lord? Can you keep it tomorrow?
All right, madam. But tomorrow you will argue. Done?
Yes, Lordship.
Yes. Come tomorrow prepared with the. Yes.
Great.
Next.
This is my application, my lord. Package. My lord, this is also applications for expeditious hearing of this application. My lord, the petitioner before your lordship is age about 76 years. But the original application was filed, lordships, on 2009. And private respondents subsequently they have made addition of party and they have made another application being OA number in the year 2019. Lordship, kindly come, if you lordship come the page 29, that wherein, my lord, the two OA application has been tagged, and my lords kindly have look the page. The second volume, lordships, kindly page 294. Page 94, lordship, the 14th February 2022. There is the second last paragraph. Learned counsel appearing for the applicants instead MA submits that the applicants of this MA have already filed way relating to subject brought in question being number 246219, which is fixed for consideration.
Where
The
you are
next
reading? Where?
page, not a page 294. Lordship,
No, first show us the order you are challenging here.
No, Lordship, I am for
There will be
application
an
to
order of
expedite
status
the-
quo. The 29th of July 2009. Which
Lordship,
is the order you are coming up, arising
for
out of which?
expeditious trial of this
For
expeditious
expeditious
trial.
hearing.
What
I am
is
for
the
the private
Where
response.
is the last order, sir? Please show
Okay.
us.
The last order, Lordship, kindly come the page 323.
Acha, 14 June.
Page 14 June. 14 June, the last order.
Let us see what is the last order.
Lordship,
8th April it has been.
8th
Lordship,
April is
what
the last.
happened?
8th
Lordship,
April is
what happened? The private respondent have filed another application way, which has been tagged with this my application.
Very good.
And both this application is fixed on Lordship 8/4. But my application was 2009. Now Lordship is 2025. The petitioner
What
Lordship, the
happened
age of
on 8th April? Oh, 8th April to ask.
is coming. Lordship, I am praying only the early disposal of my applications, both the two applications. This application, Lordship,
Where from we will know that it has been tagged with another
Lordship,
matter?
Lordship,
Yes,
the
so
page
order already there.
294,
What is the date of the order?
14 February 2022, page 294.
তে এত বড় petition করেছো কেন?
Lordship, entire application,
The entire application, we are deciding on merits. Unnecessary.
Many orders district judge passed by the district judge and other. So many volumes.
there are Lordship,
294.
294.
Not necessary to purpose, the hearing is necessary.
That. Page 294 and 295 on 16th March 2022.
So this is OA 866.
Lordship.
294 is OA 866. And 14 June order was passed in 866. Where is the order of tagging both the applications?
Lordship, this is the 16th March.
No.
16th March 2022.
No.
16th March 2022. Both these matters be listed on the same date.
14 June order is an OA 2462.
2462, yeah.
2462.
246. Page 295, it says,
Lordship.
matters be heard together.
Well, that matters we had together, 294.
295.
But again, my lord, what I see, my lord, in the 14 June when it was taken up, both the applications were not being taken up
Not
together.
tagged up. It appears to be a counter case. List the matters for convenience of disposal. Very good. Now you are enjoying an interim order since 2009.
No, not
Without
interim
making,
order.
without making the party private respondent, just suppress all the matters. I have
We will come
Lordship,
back to you.
I have filed an application of vacating the interim order because the properties.
Who passed the interim order in which matter? His matter.
No.
My matter. The
Interim order was
status
in your
quo-
favor.
Status quo was passed, and Lordship, for that order of the status quo, Lordship, the properties, when the income, the goddess properties was incoming, but the income was stopped. Then subsequently, I compelled to file an application for vacating the interim order.
The order which was passed in your favor, you wanted vacating the same.
Lordship, kindly come.
No. What did you pray in the original application? What was your prayer in the original?
Lordship, the prayer is that the order of the DLRO which has been passed in my against
Section 54 appeal. Acha, that order is
appeal.
against you.
Against me.
So you have challenged that order in 2009.
9.
Now, why did they file? They were not implemented.
I am not
Implemented.
implemented.
So why did you file the original application?
2460.
19. Why
19.
did you file in 2000?
19.
Why?
Why will we are not aware of the said order. Also, I have filed additional party in the.
Oh, by the order, the
not
DLRO directed recording of their names.
No, 2009 we are not in picture. We are not a party. Thereafter, after
you purchase the land.
No. We are also co-sharer. We are the. I am the legal heirs of the original owner. That is the
case
No, we are wanting to know. Issue was regarding record of right rectification. Rectification. Appellate authority has held against you. That is why you have
Lordship.
Your client is 85 years old.
76.
Where you have stated?
In my affidavit. In my affidavit, I have stated.
not the fault of the petitioner, fault of the petitioners. They have changed 4 times. The lawyers have been called and changed. They have not given. So did we want to disposal of the matter?
Yes, yes,
তার
yes.
মানে কি করেছে
Yes,
সেম
yes.
অর্ডারটা প্রিন্ট করে দিয়েছে দুটো নাম্বার
Ah.
পেজ কত
Both the
কত
matters are not appearing together, my lord. Two different orders are being passed. My lord, I stand corrected. Page 315 is with regard to OA 866 of 2009. So he can be agreed with the order passed in page number 315 in this application.
yes he
Not
cannot be agreed by the other order
other order.
so this writ petition has been filed ভালো লাগেছে this is in connection with 866
866.
To which he is not a party.
To which he is not a party.
to which he is
To which your lordship rightly pointed out, he is not a party in 866.
866 কি করে ওদের না মেনে embarrassing first title
By the time you rectify, it will be 8th April.
তাকে বলেছি 2024. This ought to have been said by your earlier predecessor.
4 lawyers have been changed.
4 lawyers.
4, 5.
এখন এসে বলছে দেরি হবে। Yes, next. Has been passed in a contempt application.
No, contempt application is, we want for speedy disposal of the contempt application.
That is what we are
Many
saying.
times it was hard. It was kept part hard. It was then changed and thereafter it is again hard.
So your MA 1002 is a contempt application.
Contempt application.
So
on
this
17th
was
of-
filed in 2010. Then it has been adjourned from time to time.
Every time adjourned on various ground in the COVID period is liable for some time. But other days, my lord, sometimes may changes, sometimes
No,
Both-
sir, how you have, Mr. This respondents whom you have implemented, same persons were there in your MA application.
No, no.
তাহলে- Then it is
Because-
defective.
difficulty is this, my lord. If we want to add the present incumbent, then we went to a tribunal. On the 17th of June, it is date fixed for hearing. In this way, my lord, years after years, my lord, adjourned.
No. In your contempt application, sir, these persons are new incumbents. They
Yes.
were not there in your contempt application.
Right.
So you have to take leave from the tribunal to implead the new
My
incumbents.
lord,
But you cannot strike out the old incumbents.
no,
They
no.
will remain.
No.
So please
That
show
is
us that. Please show us that there is no defect in the cost title.
no, there is no defect because there are other, all the contemners, alleged contemners are parties in this
Show
application.
us that portion.
That is at page
40.
Page 2. One
Your
after another. one
Your
after-
MA 1002 is annexed at page 40.
It's at page 40.
Page 40, the sole contemner was Niladri Shekhar De.
At that point of time.
Now you have added Shourangshu and Abdul Jalan.
Yes, ma'am. My lord.
This you cannot automatically add. You have to take the leave of the tribunal.
That will be done. That will be done.
That has not yet been done, so the cost title is wrong. Have we been able to?
But what I am submitting, if the tribunal, government representative is there, he will represent the alleged contemner. Fixed, my lord. Government representative representing the the cost title, we have all the alleged containers. are
Cannot.
At page
আমি
2.
বোঝাতে পারছি না। You cannot do that, sir. You have to first take leave, implead, then you can come to us. That see how long the matter.
The earlier occasion, taking leave one after
আচ্ছা,
another.
who is your private who is his state? সিদ্দিকি কোথায় গেল? সিদ্দিকি, where is সিদ্দিকি? What was the contempt? Show us the main order.
Main order was passed disposed of by the tribunal.
Where? Show us that order.
Original order was passed disposing of the.
Now
That
we will
is-
solve your problem. Call Mr. সিদ্দিকি। আচ্ছা, একটু দেখে দাও। হ্যাঁ। This is page 66.
My lord, that is original order, page 26, annexure P2,
Just a moment. Page 26.
page 26. That was the order passed by the
learned members of the tribunal,
Very good.
original
This was,
application.
this was passed
That was
on.
disposed of. Directing the BLRO,
কবে কবে অর্ডার হলো এটা? 8 জুন 2007
2007.
বছর কন্টেম্প চলছে 10 বছর 15 বছর ধরে।
Now it is ready for hearing. We submitted written argument. Both the parties filed their respective written argument. Notwithstanding, matter is adjourned. They submitted compliance report. We took exception to that compliance report.
ডিসাইড করে এবার বিএলআরও কে বলেছে হাইকোর্টের অর্ডার
Compliance report of right.
কমপ্লায়েন্স রিপোর্ট হয়।
You've challenged the compliance report.
Oh, yes. Took exception to that compliance report and we submitted objection. They submitted written argument. We submitted written argument. Date fixed on 17th of June 2025 for hearing. We want so that no further adjournment be given either of the parties without unnecessary adjournment. This is my prayer.
When did you file? They filed compliance report. You have
Compliance.
filed exception to that.
Exception to that compliance report.
Acha, and it was made ready for hearing which order?
Made ready for hearing at page 70,
70.
70, Annex Chapter 12. Let the last line, let the matter appear in the list under the heading hearing on 5th of July 2022 at page 70 towards bottom. 5th of July 2022.
এটা কি করে রিমুভ করে? Acha, these two persons whom you have added, one Shorangshu and Abdul.
That was with the leave of the.
You have done
planet
it?
time. Yes.
Where is that order?
That order was not given, but we made party to them
They were made parties. How will we understand?
in the cause title.
Are সেটা is in your cause title.
Yes,
Before the tribunal they were.
At page 2.
Are page 2 we have seen. We are asking where in the original application you added them.
Time to time allowed
কোথায়
me.
কন্টেম্পটের পিটিশনটা কোথায় যে you have added?
Planet members allowed me to
Show us that
add
order.
the.
Show us the order by which it was allowed. Show us that order.
Keep it at your Lord. I will produce all the records. All the records, all
Is
certified.
there an order, sir, allowing you to add them as parties?
My lord.
Where is
Yeah,
it? Have you stated that? Have you stated that in your petition? That the new incumbents were added?
No, that because my lord, even on 17th of June, if it is hard, then again I have to include the present incumbent
Naturally.
in the cause title.
Those two persons have also gone.
Also gone.
Shubhrangshu and Abdul Jalan.
Yes, ma'am. They are no longer in the service. Therefore, every time I have to take step for adding the new incumbent. This is my difficulty. It is now ready for hearing. Only learned members of the tribunal should dispose of on that day or sooner to that date.
এদের দুজন কি who filed the compliance report?
BLR Kharagpur 2. It is actually filed through the government representative.
Ashokan. 2022 সালে হিয়ারিং মিটিং ওটা কোভিড পিরিয়ড ছিল না, এটা কোভিড এর পরে পরে the present application, the present writ petition arises out of an order. Tribunal, High Court passed an order, thereafter tribunal passed a final order in the year 2009. Then contempt application was filed. Contempt application, written arguments exchanged, everything done, still the matter is being. The problem here is the contemners are changing. Now he has impleaded 2 persons. He says that those 2 persons have also gone. Now if it is taken up next, কিন্তু ও কি করবে?
কারা কন্টেমনার আছে?
আছে বিএলআরও
বিএলআরও আছে কোথায়?
নতুন খড়গপুর
খড়গপুর।
I am to add this.
এখানে লিখে নাও, we will engage you and
Again I am to
affidavit
add
of service টা কোথায়? Where is affidavit of service?
no service has not
না
reported.
সার্ভিস করেননি কাউকে?
কাউকে করবো পয়সা সব নেই, they are no longer in service.
তাহলে আপনি বুঝছিলাম
তুমি পান
They are impleaded by name, my lord.
হ্যাঁ
পান নিচ্ছে একটা
Contempt application they have been impleaded by.
with the leave of the I am to add.
না না, have you served this petition upon all?
To whom?
না না যারা ছিল তখন, যারা পার্টি ছিল,
Then we
সরাংশু বদনারি আর
serve them.
Where is that opposite affidavit of service here?
সার্ভ করেছেন, সার্ভিসটা কোথায়?
Tribunal.
No, here, where, have you served this petition?
They are no longer in the service.
Have you still served them?
No.
Even if they are no longer there.
But they have been impleaded as respondents.
As long as they are arrayed as respondents.
অফিস তো আর নেই ওখানে।
আর আপনি সার্ভিস করবেন, নেবে কি নেবে না সেটা পরের কথা।
Very well, my lord, take it another day, but I will serve in the meantime. ওরা তো ওই পোস্টে নেই এখন।
The state is not, my lord, I do not have, my lord, my lord, I do not have any problem, my lord, since your lordship, but the state is not a party in this proceeding. The officers by name are parties in this matter.
Contempt proceeding হলো
But I cannot, my difficulty is this, my lord.
We went to serve the office of the learned GP.
But ওরাও নেবে না।
নেবে না কি করে?
নেবে না।
এটা তো নিতে পারে না, এটা তো
হ্যাঁ।
contempt personal matter.
হ্যাঁ।
Contempt is between court and the contemptor.
The only difficulty.
চিট ট্রান্সফার হয়ে যাচ্ছে তাদের মধ্যে। ফেঁসে গেছে।
তো তাদেরকে
I am for the appellate.
Lord, I beg to appear on behalf of respondent number 429, Lordship.
I am for union of India. I pray, my lord, 1 week time, my lord.
Lord, there was a direction for filing
Should be
affidavits.
prepared, my lord.
Lord,
For some old documents are to be traced out. kindly allow me.
এটা করতে পারেন না। We were against you.
I beg your lordship's pardon.
We were against you. We were about to dismiss.
Lord,
However, we asked him to
Kindly.
Sir, all the records I have annexed.
like কিছু নেই। দেখি একটু কি আছে। সব চান্স লিটিগেশন পেয়েছি তো। দেখি। It is that areas na ki baki.
No, my lord, my lord, sat for interview. He participated in the selection process. And my lord,
Kindly give.
your lordship was pleased to direct me, my lord, to produce the records.
Fix it. My lord, kindly. If I fail on the next day, your lordship will take up.
Mr. Dotto,
My lord,
how many times we can
that's
adjourn?
true, my lord. I am extremely sorry, my lord, but it could not be done. Kindly give me 1 week time.
Reply you have filed. Reply to this have you filed?
No.
Opposition have you got?
No, we have not filed it. But I have prayed
তবে
for
আজকে দিয়েছো?
No.
আগে দিয়েছো?
Yes,
1 week back.
summed up.
You have not prepared the reply. Mr. Chakraborty, learned advocate appearing for the respondent numbers 4 to 9. You have filed any
No.
files the affidavit?
I'm not. Met please, Your Lordship. Madam for the petition. Appellant. Here's the affidavit itself. This,
217 days delay.
yes, madam.
সিঙ্গেল জাজের নাম ভুল করেছো? You have made the corrections.
But I did not do this, madam. Corrections, madam.
এইটা ওকে দাও এখানে। কত রকম এক্সপিরিয়েন্স করে।
But the spelling, my lord, I have just made a mistake, my lord, in the spelling. My lord, may I be permitted to, my lord, correct this, my lord?
Your section 5 is there.
Yes.
How many days delay?
My lord, the delay is of 270 days.
Then you correct in the
I'm just praying your lordship's leave so that I can just do the in course of this. My lord, my section 5 application is scan 2 of 2024, my lord.
This was an order passed in contempt.
Yes. Paragraph 3, page 3 of the application, my lord, I have tried to, my lord, explain the delay for approaching before the Honorable Court. But here, my lord, what happens?
But how this appeal is maintainable?
Yes, I'm coming to that. My lord, here, initially, my lord, the order was passed by the Honorable Single Bench, my lord, granting, my lord, directing the cooperative bank, my lord, to work out, my lord, what is the provident fund dues of the deceased husband of the appellant. And thereafter, my lord, that was not done. Contempt was filed. So in the contempt, my lord, the cooperative, my lord, came and they said that basically this incumbent was dismissed from service previously. Since he was dismissed from service, he will not be given with this kind of benefits. So, my lord, in that particular contempt application, my lord, the honorable single bench was pleased to observe that I suppressed my dismissal. And this is why the order ought not have been passed. So, my lord, basically a new order has been passed, my lord, in the contempt petition. So, since, my lord, it is a new order passed in a contempt petition, my lord, I prefer this intra-court appeal. My lord, I am, my lord, having this honorable court as well as the honorable Supreme Court's judgment to this effect that I can do this. May I place your lordship that thereafter, my lord, I'll be coming back to your lordship in this merit of this matter. Only 2 paragraphs of the honorable.
No, that you will do, but where is that first order?
Yes.
You are the wife.
I am the wife, my lord. I am a septuagenarian, my lord, cancer patient, wife of the deceased employee. My lord, if I request your lordship, my lord, I have filed, my lord, another application for appropriate order. Lordship will kindly seize the application for appropriate order at first, my lord, kindly seize, which is, my lord, can number 1. In my applications for appropriate order, my lord, I have annexed the order of the honorable single bench in the past in the writ petition.
Page?
Yes. My lord, page number 65 of can number 1, my lord. The observation, my lord, starts from running page 66 at the bottom upon hearing. And the operative portion, your lordship will find running page 67 at the bottom.
Then what happened after that?
My lord has seen, my lord, page number 67, the operative part for calculation of the provident fund amount. And my lord, the gratuity amount, calculations of them to provide that, and thereafter petitioner will be entitled to withdraw. So, my lord, after that kindly comes, my lord, to the next page number 69.
Inform the petitioner about the details of the provident fund account and in respect of gratuity and suspension.
Grateful. That is the direction. My lord, kindly comes to, my lord, page number 69. It is the order impugned before my lords. Page number 69, my lord. Order dated 18th of August 2023.
So you were dismissed from service in 98, but you expired in April 2017. No?
17. So, my lord, admitted position
The
that I
husband in the lifetime did not do anything.
did not challenge the order of dismissal.
Dismissal was not
Not
challenged.
challenged, my lord. I find from the record it is not challenged.
Very good.
Though, my lord, my client cannot, my lord, assist on that, but from the records, my lord, I find that it is not, they did not prefer.
No, his dismissal was, his suspension was due to pendency of a criminal proceeding.
That criminal proceeding, my lord, came
Acquitted.
to be acquitted, my lord, in 2015. So in
2015.
2015. So after 2015, my husband, my lord, made an application so that he gets all the benefits by saying that since my disciplinary proceeding was also on the same charge, give me all the benefits.
But dismissal, Mr. Rai,
That is there. Yes,
then
my
what you are entitled to?
now, my lord, I tell your lordship, my lord, after that, my lord, what happened? The department says that your this criminal case is still pending because we have preferred an appeal in the High Court. This is why we cannot give you any details about the Provident Fund.
So very good. Then what happened?
Then, my lord, he passed away. Then, my lord, I made a representation.
So court said that you give him the calculation.
Yes.
Now what they have done in contempt, they did not give.
They did not do, my lord. I came before the this honorable court in contempt. Then, my lord,
But what are your dues, Mr. Rai? You are a dismissed employee.
my lord, yes, my lord,
Does anything remain?
my lord, I tell your lordship, my lord, the gratuity amount, because the gratuity amount, a meager amount was offered to be paid, not paid, was offered to be paid. That was also, my lord, not properly calculated, which, my lord, I disputed in the previous occasions. The other benefits of leave, the other benefits as well, my lord. So, what happened, my lord, after this, my lord, this incumbent, my lord, this writ petitioner, when my lord came before this honorable court, my lord had, I found, my lord, from the writ petition. My lord, I found, my lord, in the writ petition. I'm sorry, I'm so sorry.
Sir, what is there any due payable?
Your Lordship, prior to that, Your Lordship, I will take instructions to that regard.
No, we are suggesting one thing. Whatever is your viewpoint, suppose 10 rupees is admittedly payable to her. We will ask you to pay that amount to her. And if she is agreed by that, she will challenge. But we will, contempt proceedings have already been dropped. If you can take instruction only to that effect.
Your Lordship, I shall take instructions as Your Lordship has desired. But Your Lordship, possibly this writ petition was filed under Group 5 and the appeal.
Forget it, sir. Person has expired. Person has expired. She is a widow. Whether she committed fraud or not is an issue to be decided.
No, Your Lordship, I am just on the point of determination. I have no issues to appear before Your Lordship.
Determination.
Group 6 data.
Possibly this writ petition was filed against the cooperative society under Group 5.
Determination Group 6. At that particular time, the Honorable Single Bench was also having the determination Group 6.
Group 6.
Your Lordship, Group 5. Your Lordship, I have got the cause list of that particular date on which this impugned order was passed.
I just check, my lord, and
it was under Group 5, Your Lordship. Possibly this was under the Group 5, the single judge's order. 18th May of 2022, Your Lordship. The impugned order is not the impugned order, the subject matter of the initial writ petition. The order was passed on 18th May 2022.
Since, my lord, perhaps it was because of the service, relating to service, my lord.
20th May 2022. Your Lordship.
Filing slip, you must have written Group 5 at that time.
March 18th May, Your Lordship, it was Group 5.
I have annexed the copy of the writ petition, my lord, but that page, my lord, is not.
The cause list is showing that Justice Bhattacharya was at that point of time exercising Group 5. As because this was a dispute between the employee and the cooperative society, it must have been filed under Group 5. And Your Lordship, the appeal is, Your Lordship, Your Lordship will decide.
We do one thing. You take that instruction.
Yes.
If we have to release, we will release. No
Lordship,
problem.
we have no issues to appear before Your
Lordship. We just want to... Mr. Rai then show us at that time it was Group 5, he said.
But even, my lord, in the writ petition which I have annexed, that
Yeah.
page is missing.
So either you can check up or we can release. Check up and come. Check.
I'll-
No, no, not
Hold on,
that.
যখন নিশ্চয়ই থাকবে।
The filing from first page.
First page of the filing.
Presentation.
First list of that day, your lordship, when the order was passed.
No, no, not because it is presentation form. It has to be written na group 5 na ki. Check that up and
My lord.
then when do we keep it?
But, yeah,
Next Tuesday. Next Tuesday অনেকগুলো হয়ে গেছে না? Next Tuesday.
Your lordship, we shall also take instructions in the meantime.
The fees for it. Affidavit of service as file be kept on record. In course of hearing, Mr.
Grateful.
Lord, item number 11, my lord. Lord,
affidavit is complete.
No, has not been made, my lord, because, my lord, some admitted position is there, my lord, that they will, some admitted position is there, my lord, because they will get the pensionary benefit, my lord, in view of the decision of the Supreme Court. It is the admitted position now. And my instruction from the bank, my lord, that they have already issued, my lord, the order directing to get the pension in terms of the order of the Honorable Supreme Court. So they are just claiming that the employee ID number and PPO number is necessary for identifying these writ petitioners, whether they are getting the same or not. Without that number, my lord, it is very difficult for the bank to trace out whether they are getting that benefit or not. So let them supply the, it is very simple for them, employee ID number and the PPO, PPO number, so that it can be ascertained whether these particular persons are getting those benefits or not. Because after the order passed by the Supreme Court, my lord, bank has already, my lord, issued the.
My lord, I am coming, my lord. My lord, I am coming.
So it will be
My lord,
easier for
it
both
is-
of us, my lord.
My lord, it is, my lord. My lord, let the matter be, my lord, clarified in a short manner, my lord. My lord, petitioners are the, my lord, ex-employee of RR Bank, Regional Rural Bank. Initially, my lord, they were not getting pension. 2011, my lord, a writ petition was moved before the Karnataka High Court. Honorable Karnataka High Court, my lord, passed an order in favor of the employees that they are entitled to get pension at per the sponsored bank. Because, my lord, every RR bank, there is a, my lord, regional bank, there is a, my lord, central bank, central government bank. Now, my lord, when this matter went up to Supreme Court, my lord, Supreme Court also upheld the decision of the, my lord, Karnataka High Court as well as, my lord, Rajasthan High Court division bench, and held that yes, they are entitled to get pension immediately the next date of their retirement. My lord, that was not complied with. Contempt petition was filed. In the meantime, my lord, we also made this present writ petition before this honorable court, playing two-folded prayer that we are entitled to get the pension as per the order of the Honorable Supreme Court, and the pension which was, my lord, granted by the authority concerned from 1/4/2018. My lord, we have got only, my lord, 2/3 pensions first 17 months, because, my lord, we have
got some commutation. That was, my lord, deducted from the date of their, our, my lord, that is 1/4/2018. That, my lord, the day of the, my lord, first date of the, my lord, my lord, pension amount, which they have selected. My lord, our prayer before your lordship, that 2000, as per the Honorable Supreme Court order, initially, the bank authority.
What did the trial judge say?
Yes.
My lord, trial judge says many things, my lord, but they have not touched our second point, which now we are hesitating before your lordship. The point is, my lord.
77 is the trial judge order.
My lord, the point is, my lord, that from 1/4/2000, these date are vitals, my lord. 1/4/2018.
So he is saying that some particulars are required for disbursement. What he is saying?
My lord, I do not know what he is saying, my lord. Here we have challenged that we have got 17 months salary, 2/3. 1/3, my lord, we are seeking, because, my lord, the point has come regarding date of commutation. My lord, if your lordship kindly turn to page, first page.
Mr. Rahman,
My lord,
you are claiming 1/3 of the benefits.
for 17 months from, my lord.
First, let us
My lord,
ascertain whether
my lord,
they are giving this to you or not.
my lord,
If they give this to you, your problem is solved.
my lord.
Now, Mr. Mokar, what is your argument?
My argument is that, my lord, the second point which my line is raising, that is not applicable in this case. Because, my lord,
Then that has to be adjudicated.
that has to be adjudicated.
Then
Because, my
what
lord,
is
it is
due to him? What are the admitted payments due to him?
admitted payment means, my lord, actually in terms of our regulation, in terms of the regulation of the bank, which are prevalent at the time of the retirement.
No, what you are agreeable to give
Agreeable to comply with the order of the Honorable Supreme Court. And Honorable Supreme Court was pleased to direct that they will get their benefit from the date of retirement. So subsequently, on the basis of that order, my lord, the regulation has been amended. Now, amending the regulation, bank agreed to comply with the order. They're bound to agree the order of the Honorable
Supreme Court.
Lordship. Now, it is difficult because in the same name, there may be 2 or 3 or 4 persons. So it is very difficult for the bank to identify these persons. So the bank are claiming that give their ID number. Only
They are
PPO
your
number.
employees, no? They
Your
are
lordship?
your employees.
Yeah, my employees. And in one name or other
So
name,
what do you want?
only 2 things are necessary. One is their employee ID number, and second is PPO number. 2 is sufficient for identifying the same. I don't know why my land is disputing that.
What do you want?
Employee ID number.
ID number.
Yes, and PPO number.
Was PPO issued by in their favor?
Issued in their time issued there.
Page
So they let them
134 and onwards. My lord, my lord.
PPO number.
No, pension was disbursed in their favor.
Yes.
That is
They are claiming that lordship.
They are claiming the thing
date
which
of
was
retirement.
granted by Supreme Court.
Lordship. From the date of retirement, because that was not given in terms of the
So
regulation.
now you are
We are agreeing.
You are ready
We are
to pay.
agreeing, but let them supply the index number, PPO number. Very simple.
Then
My lord, I am coming. My lord.
No, do you have the employee ID?
Yes, my lord, that documents I have annexed in the writ petition.
Show us.
Page 134. My lord, before that, my lord, I want to, my lord, disclose.
We are not wanting to go into the details.
My lord, because
we are wanting to know whether the admitted amount which they would be giving to you.
Yes, my lord. Lordship, kindly come to page 134.
So if that has been annexed to the petition, Mr. Mokaram, why your clients are taking a different step?
My lord, let my landlord indicate, my lord, from 134, page 134.
My lord. Lordship, kindly page 134, number 1, PPO number.
134, it has been given.
Where will we find the employment ID?
Lordship.
My lord, I am coming, my lord. My lord, here my claim.
Pension payment order is sufficient for identification.
Lordship, but my lord, in this, my lord, that bank is not a little bit confused, my lord. So they are claiming, well, they have got the index number, so it is very easier for them to supply the same. There is no dispute that they have got the ID, employee ID. Why they are, my lord, reluctant to supply the same? Bank is agree. If they supply, the matter will be solved.
You must be having the ID.
I'm coming. Only 2 minutes time, give me. The problem is arise from, Lordship, kindly see serial number 21.
Page
134.
The years.
134, page serial number 21 and 22. Commutation date 1/4/2018. My lord, what is the 1/4/2018? Initially, pursuant to the order of the Honorable Supreme Court, the bank regulated a formulation, formulated a regulation regarding the pension scheme. And they have selected that the persons who have retired from the bank will get pension on and from 1/4/2018. Those who have retired before 1/4/2018, they also get from 1/4. That was challenged in the writ petition. And subsequently, Supreme Court contempt petition, that has been clarified. My second part is
clarified to what?
Supreme Court,
Possibly not.
Central government. So central government submitted a affidavit disclosing that they are entitled to get all the employees.
So what we understand is you are not agreeing to the commutation date.
Yes, my lord.
So this commutation date, according to you, is erroneous in view of the judgment of the Supreme Court.
Not only, my lord.
My lord. Now this argument of yours was turned down by the single judge.
Single judge.
So you people are all retired persons.
My lord.
So if you give the employee ID and if they disburse in terms of this PPO, that will be without prejudice to you.
My lord, that I have to take instruction first thing.
Mr. Rahman, please, we are trying to solve the problem. No use going into a detail. Suppose if 1/4/2018 is the date taken, which according to you is wrong, that will be considered by us. But accepting this PPO, why don't you take the admitted dues with you? That admitted dues will be taken in terms of our direction. That will be without prejudice to your rights and contention. Then we will get time to thrash out the issue as to whether this commutation date is belated or it should be earlier. Then finish problem. So if they are agreeable to give you the admitted dues according to them, if you provide the employee ID, what can be the problem?
There is no problem.
Then
only I, being an officer, I want to disclose some facts before your lordship.
We will listen to you. We will listen to you, but not at this stage. You get the money.
My lord. Only 1 minute, my lord.
Mr. Raman, we are telling you what you. This is a group litigation. There are many persons.
My lord.
You call your client.
My lord.
And you tell
some
them
of
what
them
the court
expired.
is wanting to do.
My
Tell them, explain them that court is wanting to do this.
My lord.
For that, the employer ID is necessary. And you assure them that the court will consider your grievance even after you accept this money. We will not leave them. If that is solved, then you give the employer ID. We give a time to them. They will disburse the amount, give your bank particulars.
আছে তো হ্যাঁ
কোথায় এই নাম্বারটা কোথায় যে কোনো সেটে এই তো সেট এখানে না ওই এখানে এটা পিপিও নাম্বার এই যে এটাই বলে আইডি এমপ্লয়ি বলতে আমাদের ব্যাংক কার্ড রিটায়ারিজের একটা কার্ড আছে Retired is একটা কাট
Mr. Rahman,
back to
you sit with him and discuss and come back. Not this manner.
my lord, kindly excuse me, my lord. Kindly excuse me.
Call them.
My lord.
Call them, you ask them. If they say that they don't have the employer ID, then we will think about what.
My lord, my lord,
I think that will be better.
my lord, my lord.
So tell us, when can you come with this idea?
Why করবেন আজকে? কবে interview?
When do you want to come back, Mr. Rahman? When do you want to come back?
Okay. Huh? My lord, today হবে না, today না তো fixed থাকে। My lord, one day accommodation, my lord. রবিবারে হবে। সোমবারে ঠিক।
In course of hearing, Mr. Mukha. You will bring it in court. And the PPO you have already annexed, you will indicate the page numbers. Huh? We will accept that and we will give direction to them so that the necessary disbursement. Oh, the bank particulars. Bring your bank particulars.
But they will supply the copy of that chart.
আগে আমাদের দেবে, then I will send you. I will not leave you, Mr. Mukara.
We must not oppose the prayer matter which is legitimate claim.
That is your voice has come down since we intervened.
No, sorry. Pardon me, obliged.
চলো ডেকে দাও। হ্যাঁ? ও আচ্ছা আচ্ছা, পাঁচটা বলতে। Oh yes.
I was there when I stuck up in the content.
But we were here.
Sorry, forgive me.
We were not missing. কি হলো? কি decide হলো?
Mr. Dhar was there when he was leading me in the earlier occasion, my lord.
He decided, Mr. No, he could not say anything.
Yes, my lord. One thing, my lord, when I submit before lordship, we had a talk with our client regarding this withdrawal. My lord, one thing, my lord, kindly consider the order itself, my lord. Order impugnated itself says that some practice has been done by the learned advocate. That stigma is still there.
Has been done, my lord.
If that be so, my lord, it is not the learned advocate who has said. Mentioning was done, it was entered into the list.
But it does not say about the learned advocate. It says
Yes.
there's some practice which is involved. Does not say the advocate.
Yes, my lord, kindly consider internal page 2 from the top.
Yes, I've seen.
It was mentioned, my lord knows better than us, my lord. No. The matter has been upgraded in that matter. It is not that he said that this matter pertains to this. Matter was running in the list, mentions. Now I am not on that. So this is the allegation. What, my lord, I am praying before your lordship, my lord. If I go back after withdrawal, my lord, this will remains. Then I cannot approach that court also for upgradation.
But Mr. Roy, how can we alter this order? Tell us.
No, my lord.
You are first our officer.
That.
Then you are the litigant.
No, I am not on that. Now, my lord, I will.
When as my brother has pointed out, there is some this misleading may not be attributable to the advocate, which you are arguing, because it is in a fresh paragraph, and his lordship says while considering the matter, and his lordship did not say and considering the matter and the submission of the learned advocate. That lordship has not said.
But previous paragraph and subsequent one, it
Why you are
one can record that one thing, my lord, may I pray before lordship. This is only for the purpose, this entire
if we
may I humbly pray before lordship, my lord, keeping aside all these things, my lord. If the authorities come up and say this is the reason, there is no reason to pending these proceedings. What is the reason for not granting that? This is the only thing. If they have any instruction, we can fulfill the same or take subsequent recourse for that purpose. Otherwise, my lord, this application in the month of
They have
yes, that is
they have a report.
yes.
You've not seen it. We have. Best you don't press. Telling you, you get into trouble.
That is why if it's false, then I'll get back the money, or that way I'll not press. I'll not press. If I can get, so I can inform the that these are effects, so don't press this. Then everyone will be my lord, substitute. We are also
The order under challenge is 12th December.
yes, 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 yes.
The matter is pending before the single bench, honorable single bench. How can this be done?
Report na dekhi kyun?
ওনারা বলছেন যে সিঙ্গেল জাজের জন্য দিয়েছে, এখানকার জন্য নয়, এই জন্য তো দিচ্ছে না। আমি যশোরের কাছে সে দিচ্ছি, এর থেকে বেশি বলার আমার কিছু নেই। কি বলবো বল?
what were the two categories? What were the two categories for
Land acquisition matters where
Encroachers.
land acquisition
land acquisition
and
and encroachment over government land, PWD land, without compensation. My lord, land acquisition,
land
acquisition
without
compensation. This a heading টা ছিল তো।
Acha, very good. And encroachment
on the PWD land, government land.
So your case was relating to influence of a mining.
Mining means the government is encroaching my land in question. That was the mentioning in, that is the reason for urgency.
Government is encroaching.
Yes, the government, my lord.
That cannot be lost. You say lease grant.
bolte dao na. Yes,
একই তো পেছন দিকে আছে। Now our case is that the government, in spite of allotting that bid, that's mine to us, but without executing any deed, now they are excavating the of their own machineries. That was the precise allegation made in our writ applications.
Show your prayer in the writ.
That is, your lordship can turn to
page 29 of the stay application.
Registered the deed and sand mining, commanding to produce the records, interim order to allow petitioners to start work.
Yes.
Where is the allegation of encroachment?
Yes, my lord. Your lordship find page 38.
Prayer is not there.
No. Prayer is on that basis, one of the allegation. That is why the specific allegation was there. Page 38, 18/4/2022.
38.
Page 38
of the stay application.
Of the stay application. Is a part of the writ application. Page 38.
We are getting this page.
Can one of 2025 my lord is 57, 50, I mean, 57, my lord. 57, forgive me, my lord. 57. The কালোর মধ্যে চলে গেছে বলে।
Yes. What mean?
sorry.
এই তো
This is your allegation.
This was precisely my allegation was there. Just so allow us to continue. Otherwise, the government is utilizing my land without after. This, it is in such a manner, my lord, it was understood. My lord, it was mentioned without mentioning anything to the extent of what group it is there. It was mentioned the honorable signatures of the opinion. It should not come there. Be as it may.
Two categories to দেখো. Two categories mentioning.
Oh yes, two categories. List আনতে হবে. These are the two categories. Well, I have a list. নেই তো না
এটা তো ওই সময় বলেছিল এখন তো আর ওই
এখন নেই তো আগে
that was the indication prevailing at that point
at
of time.
that point of time.
The honorable single judge was allowing upgradation only in respect of these two categories, which the case of the writ petition does not fall under any of these categories, and that was written in the mentioning slip.
The two categories are one is of
My lord will not find in the appellate rules, my lord.
ওই সময় লিস্টটা ছিল এখনকার লিস্ট না
তাহলে কি সেই দিন লিস্টটা দরকার
the present appeal has been preferred challenging an order dated 12 December 2024 passed by the
grateful man.
আমারটা
ওই যে হ্যাঁ
এটা কি মেনশন করতে হবে
My lord, may I have your lordship's kind leave to mention a matter before your lordships heard this matter application for review, my lord. I mentioned it also previous occasion. Your lordship allowed the mentioning, my lord. But somehow, man,
Who is your other side?
my lord, Mr. Dr. Shutanu Patra have served notice on the last occasion application. Everything served.
আচ্ছা শোনো, I will sit with my brother. We will indicate in the.
My lord, any day subject to your lordship's.
My lord, this is the compassionate appointment matter, my lord, for that particular guard, and it was scheduled to appear before this honorable bench today, my lord. This is the order, my lord. So
What happened? They have
any
not,
other convenient date.
they have not issued the approval letter.
No, my lord.
Appointment letter they have not.
Appointment letter has got, but thereafter, my lord, the great adjournment for completing the formalities.
Right.
But formalities, she got the one letter addressed to the NRS hospital, my lord, seal cover, on the just afternoon before the Holi. And thereafter, Friday, Saturday, Sunday, and Monday, he has scheduled to book their hospital. So we have to wait for up to 3-4 days. Let us see, my lord, because
Then why you are mentioning, sir? We will include it. যাই হোক ওই দিয়ে দেবে ওই কন্টেম্পটে রেখে দেবে। Yes, Mr. Sir.
May I have your lordships kindly, my lord, to mention what I'm mentioning upon notice, my lord. This is that matter your lordship will recall acquisition for the purpose of metro railway.
ও আচ্ছা আচ্ছা আচ্ছা
My lord,
ওই
the
আর্মি
consulate of Nepal building
Nepal
was being
consulate.
taken. My lord, your lordship will recall.
It is Patar.
Yes, my lord,
was
Patar.
made Patar, my lord. Only one thing, my lord, I was submitting, my lord, your lordship will recall at the time of disposal of the stay application, Mr. Jayanto Mitra appeared. We said that let the appeal be heard out. We will not take steps in the meantime. My lord, your lordship directed paper book, everything has been filed, but only problem is, my lord, this has been treated as
hard in
part by this bench, my lord. But there is real urgency in the matter, my lord. I was only praying, my lord. Now it will be difficult to get your lordship. In that case, my lord, and only the, my lord, the entire project is standstill because of only this one property.
No, you are wanting to for hearing of the matter.
Yes, yes.
So we will, if this bench will sit, we'll take up the matter.
The only thing is that your lordship kindly give us a very close date, my lord. Only I'll tell you, lordship. Otherwise, I would not have troubled your lordship. The entire project from Joka to Esplanade.
Very, Mr. Sen, we will be most probably sitting in Friday week. And Friday week, if it is there in the list, if it is taken up, we will hear and finish it up.
Friday week.
Friday week. And if per chance we are not in a position to do so, we will keep it on any particular days to be mentioned and cancel the pattern.
Yes.
As my brother had heard it
In
along
fact,
with
Lord,
me, I was.
there is no urgency. It is for
No,
exchange of land. It is
my
have exchange of land to next.
We are not going into that.
Yes, Lord, yes.
এটাকে না ওই যেদিনকে
Friday.
শুক্রবার বসবো ওই অ্যাপ্লিকেশন ছোটখাটো থাকলে এটাকে প্রথম দিকে দিয়ে
Let it be, my lord, at the top in that case, my lord.
Yes.
we will assemble. Let us see how.
Your lordship will be sitting on 28th.
Yes. Mr. Sen, I will consult with my brother. If on any other day we sit, we will sufficiently make indications so that you can.
So that we will come to know, my lord.
Yes.
My lord, may I be allowed to mention one
Your Lordship,
contempt?
kindly keep in mind about the public interest involved. That is why I was troubling your Lordship, my Lord, for a.
No, we shall keep it. Don't worry. Yes.
My lord, may I be allowed to mention one contempt application?
Whether it will be before 28, we cannot assure you, but it will be there if on 28, if we sit, it will be.
May I be allowed to mention, my lord, one contempt application? It was supposed to appear today, my lord.
Fresh contempt, new contempt.
No, my lord. It was supposed to appear today. It was a returnable date today, but it's still not. Grateful.
Item number 1 কি প্রদীপ মোদক ফাইলটা দেখো ওই জাজমেন্ট টাজমেন্ট থাকলে কি দিয়ে দাও So we have recorded the submissions and accordingly the order.
Lord, may I pray for stay of person?
My lord, I am my lord. Mr. Tarofdar, on behalf of Mr. Tarofdar, my lord.
Where is Mr. Paja?
My lord, he is coming, my lord. I already informed, my lord. He is coming, my lord, from old post office office, from his chamber, my lord. Actually, he is coming, my lord.
Yeah, what years? We will come back. With Justice Mitro, we will sit just
Yes,
after.
Mr. Mojumdar is for the appellant. I am for the respondent. OD1.
This one.
Listed.
But there has been some, we have to correct something. That is why we will sit after, once Mr. Paja comes, we will. Mr. Paja's junior is also not here.
Mr. Pole has come, my lord. He informed, my lord, and one matter is taken and he asked to that court, my lord.
না আমাদেরটা না বুঝেছি বলছি আমাদেরটা না
এটা কোথায় অ্যাপেলেট সাইডে ছাপিয়েছো?
আবার বসবে রেগুলার বেঞ্চে বসবে
দেখো পাঁচা এলে
কি বলছে?
ফুলের এখন ভালো ধরেছে ছুটলো।
We have, there was on our officers' part, there was an he didn't consider that. We are recalling the order, we are constituting a bench with justice sent today itself at 4:15 p.m.
Again,
We will deliver the judgment.
no, I know. But
You are in problem.
I have some problem. I want to leave the court. I want to leave the court. But if you'll also ask me to stay here, I will stay.
So, Mr. Pajay, can you accommodate?
Yes, yes, yes. Of course.
For one day, please accommodate.
Yes, yes.
When will you be leaving? 4 o'clock?
Today, yes.
তুমি এক কাজ করো, 4টের সময় বেঞ্চ কোনোটাই স্যার একটু প্রজেক্টের
My lord, may I be permitted to mention one matter for inclusion in the list under hearing, my lord? This is a group 6 matter and paper books are, my lord, completed. I have mentioned this.
upon notice.
Yes, my lord, I have served notice by email, my lord.
Near. Yes, call
I
the
be permitted to mention on stay application and section 5 application.
original side.
Original site.
Trace application. It is a কোন সালে দেখো না 24 It did not appear earlier.
No.
Yes, madam. Yes, call the list.
Not appear for the applicant.
Yes.
Not an order passed by the municipal authorities in terms of section 397 of the KMC Act 1980 came to be challenged in a writ petition. The allegation was the plan was sanctioned or not obtained by misrepresentation of facts. Apropos the FAR. Now, during the course of hearing of the writ petition, the court felt that Rule 12 of the writ rules should be invoked and any person who is interested whose rights might be affected should be brought in the proceedings. The appellant before your lordships was added as a writ petitioner in the proceeding. Now, at the stage of hearing of the writ petition, my clients wanted to bring on record 4 or 5 documents which were essentially should have been considered by the KMC authorities in dealing with the section 397 proceeding. Namely, an application by the developer seeking permission for sanction of the building plan, then the power of attorney. Number 3, the types of deeds which had already been conveyed in favor of the purchasers, which would show the area of open space to be maintained and the FAR that was sanctioned. But this was principally disallowed on the ground of delay, number 1, and number 2, introduction of the documents would change the nature and character of the writ petition. This is why
How many appellants are there?
2.
They are the
added writ petitioners.
They are the added writ petitioners.
23 and 24.
What was the writ petition about? What was the prayer in the writ?
Not challenging an order passed by the municipal authorities by which my complaint as regards section 397 was rejected. Not my complaint was rejected.
Complaint of your fellow.
Yes. But probably the Honorable Single Judge proceeded on the principle of amendment of a writ petition rather than not considering that in a writ proceeding. It's a trial on affidavit where the pleadings are taken as evidence and not the annexures or exhibits. But what was the nature of documents? 1, a form which was submitted by the developer for the purpose of sanction of the building plan. Number 2, a sample deed. Number 3, public records, which we obtained through screenshots from the website of Hira as it then existed. I mean, in all fairness, these documents.
The plan was sanctioned in favor of this Bengal Peerless. And who was the developer?
They were the developers.
Bengal Peerless was the
developer, right?
And it was entered into with the housing board.
I know.
So that
Clearly, joint sector company housing board represented.
But some of the documents.
So the promoter was the housing board.
No. Response number 8.
Both.
Maybe joint
sector.
Promoter was Bengal Peerless.
SPV.
Not in the pleadings before the Honorable Court.
No, didn't the writ petitioner rely upon this agreement at the time of hearing of
Some were not relied upon. The documents which were sought to be introduced through supplementary affidavit were not on record. In response to the writ petition, the West Bengal Housing Board used an affidavit seeking leave to produce some of the documents which were actually not produced. This is the sole scope of the appeal.
Where's the influence order?
Please come to the 3rd February 23 order. Annexed to the memo of appeal as well as
Your Lordships may straightway come to page 5, the last 2 lines on that page. The case made out in the writ petition is that the residents of phase 1 have acquired exclusive right of so and so acres out of 12.27 acres of land by virtue of registered sale deeds and therefore have exclusive right to available unutilized FAR at phase 1 which can never be transferred for future development at phase 2.
Where you are reading?
I am reading the last 2 lines at page 5. Internal page 5 of the Honorable Single Judge's order.
Yes.
May I please? The case made out in the writ petition is that the residents of phase 1 have acquired exclusive right on 9.04 acres out of 12.27 acres of land by virtue of registered sale deeds and therefore have exclusive right to available unutilized FAR at phase 1 which can never be transferred for future development at phase 2. The further case made out in the writ petition is that the form 1A has been filled up by the 8th respondent disclosing that the proposed project is of modification and expansion of a residential complex and the project area of land was given as 12.27 acres. It is specifically stated in the writ petition that such statement is erroneous, misrepresentation of facts, and also an act of fraudulent activity since the 8th respondent was not the legal owner of the entire piece of land on which the calculations have been made while applying for the environment clearance. From the first affidavit, there's the first supplementary affidavit that the added writ petitioners wanted to file. It is evident that pursuant to the application under the RTI Act dated 24th October 2017 made by the original writ petitioner, namely so and so, KMC supplied the documents along with the letter dated 7/11/2017. It further appears therefrom that a demand notice dated 7/11/2017 was also issued to the said original writ petitioner towards the charges for copy of the sanction plan and other charges. The copy of the notice under Rule 4.2 of the KMC building rules was also supplied to the original writ petitioner. In spite of receipt of the said documents sometimes in the year 2017, the said documents were not made part of the writ petition which was affirmed by none other than the original writ petitioner number 1 on 9/7/2018 and filed before this court on 10th of July 2018. Instead, the original writ petitioners proceeded to advance arguments in support of the writ petition. The arguments on behalf of the original writ petitioners have been concluded prior to the affirmation of the first affidavit. The first affidavit is silent as to how such documents were procured by the added writ petitioner. Now, this is probably the first ground. The added petitioner numbers 23 and 24 seek to bring on record the documents when their turn came to advance arguments in the writ petition when the same was consciously not produced by the person to whom the same was supplied by the KMC. Such practice of introduction of documents in installments by different groups of writ petitioners is not appreciated by this court. Not pausing here for a moment. The court passed an order inviting parties who intended to be added as parties in the writ petition. All persons. There was an order of this court in terms of Rule 12 of the writ rules. The other document annexed to the first affidavit is the agreement between the 7th and 8th respondent dated 8 July 2009. But this is the developer's power of attorney. Though it has been stated in the said affidavit that the deponent obtained the said agreement very recently, but when and how such agreement was obtained has not been disclosed in the said affidavit. Furthermore, when in the deed of conveyance annexed to the writ petition, the reference of such registered agreement was made, this court fails to understand as to why the deponent of the said affidavit took such a long time to obtain the same. Such delay remains unexplained in the instant case. The added petitioner numbers 23 and 24 sought to make out a case by filing the first affidavit alleging that there has been a violation of the conditions contained in the agreement between the 7th and 8th respondent dated 8 July 2009 while submitting the application for sanction, which amounts to misrepresentation and fraudulent statement under section 397 of the 1980 Act. The said case was neither made out in the writ petition nor the same was urged before the authority whose order has been assailed in this writ petition, but this is factually incorrect as the records will show. After taking note of the case made out in the writ petition, this court is therefore of the considered view that a totally new case was sought to be made out by the added writ petitioners on the basis of the documents annexed to the first affidavit. After commencement of hearing of the writ petition, the practice of filing supplementary affidavits by annexing documents to bring out a new case has been disapproved by a division bench of this court in so and so.
Just any affidavit has been affirmed in this?
Yes.
Our opposition.
Opposition reply.
Yes, well, opposition has been.
All right.
একটা সেট কেন? Opposition has been. Yes, well, 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 opposition has been.
Two sets. একটাই সাদা কাগজ হয় একটা? এরকম একটা একটা সাদা হয় একটা? জানি না কোথায় গেল, কোথায় চলে গেল কোথায়?
So Majumdar, the writ petition was filed in a representative
সাদা ঠিক আছে?
It was initially filed not in representative capacity, but there was an order passed in terms of Rule 12 of the writ rules. Since the Honorable Court Judge felt that rights of several persons may be affected. So we got added.
It's not an order one rule 8.
In the nature of at them.
But if it is.
In the nature of.
If it is in the nature of, then you know that you have to be all bound by the pleadings of the original plaintiff or petitioner.
No new pleading was sought to be introduced.
So if you're filing a supplementary affidavit.
To bring on record these documents. Documents were disallowed and not, as you have tried to learn, not in a writ proceeding, annexures or exhibits, nothing else. After taking note of the case made out in the writ petition, this court is therefore of the considered view that a totally new case was sought to be made out by the added writ petitioners on the basis of the documents annexed to the first affidavit. After commencement of hearing of the writ petition, the practice of filing supplementary affidavits by annexing documents to bring out a new case has been disapproved by a division bench. Not in this judgment. Then not the judgments are. Please take the next page. Pursuant to the application filed for addition of party, the petitioner numbers 23 and 24 were added in the category of the writ petitioner. Upon being added, the added writ petition numbers 23 and 24 are bound by the pleadings of the writ petition. It would be relevant to point out at this stage that the prayer of the added petitioner to file additional statement or pleading was not allowed by a coordinate bench while adding them as parties. In view of such undisputed factual position and applying the aforesaid well-settled proposition of law, this court is of the considered view that the submission of the learned senior counsel deserves to be accepted, that the new case sought to be made out by way of supplementary affidavit should not be allowed.
What is the new case? That the sanction was obtained by suppressing the terms of the agreement.
Not the new case was by reason of misrepresentation of fact, additional FAR was obtained. But I shall show to your lordship the order impugned in the writ petition that will.
9.08 was they actually obtained for 12 point something, showing that the entirety is owned by them. That's the case.
And what these documents would show as to how the developer proceeded in the matter of obtaining the sanction plan.
So that agreement was never disclosed by the writ petitioner.
It was not disclosed, although the reference was made to it, but it was not the document was not disclosed.
Reference was made in the petition.
But as I find from the order, I just read it. Please come to.
Also, Mr. Majumdar, we are slightly bothered by.
Please come to page 7.
No, just come to page 9 first.
Pursuant to the application
No, hold on. Read from the 4th line. It would be relevant to point out at this stage that the prayer of the added petitioner to file additional statement pleadings was not allowed by the coordinate bench while adding them as parties. Did you challenge this order?
No. We wanted to supplement the writ petitioners by filing.
Did you challenge this order?
No, it was not challenged. We did not.
Accepted it.
I accepted. I did not file any additional pleading. I said, please allow us to rely on these documents.
Statement pleading.
Pleading. So no new pleading was allowed.
Just documents. When you filed the supplementary, it was just the
documents. Just the documents explaining the relevance. Not the basic allegation of the plan having been obtained by misrepresentation of facts.
Show us this order. This order
that order of
was rejected.
Not, I'll try to find out.
All right.
In view of such undisputed, I just read on. In view of such undisputed factual position and applying the aforesaid well-settled proposition of law, this court is of the considered view that the submission of the learned senior counsel deserves to be accepted, that the new case sought to be made out by way of supplementary affidavit should not be allowed. The case made out in the writ petition is that several deeds of conveyances were registered prior to the grant of sanction of phase 2. The date of registration of the first deed of conveyance was also stated therein to be 18th August 2016. Whether registration of deeds in respect of flats in phase 1 prior to sanction of plan of phase 2 has any effect or not shall be considered at the appropriate stage, and neither the details of registration nor the total number of registration of deeds made prior to sanction of plan for phase 2 shall have any relevance for deciding the issue raised in the writ petition, and therefore for such reason the said list cannot be allowed to be brought on record at this stage. That's exactly the issue. The delay in obtaining the screenshots of the documents available in the public domain has not been explained in the second affidavit. It is also not the case of the added petitioner numbers 23 and 24 that those were produced and relied upon by them before the adjudicating authority. This court is therefore not inclined to allow the added writ petitioner to bring on record the said document. Not a document in possession of an Article 12 authority should have been disclosed to their affidavit in opposition. In all fairness, an Article 12 authority should have come up and said that these were the documents which were available at the time of hearing, but the parties might not have produced.
Oh. Those were after the sanction was granted, the writ petitioners lodged a complaint. As the same was not considered, writ was filed.
No, not this order passed by the municipal authorities in dealing with the 397 proceeding was challenged in the writ petition.
Oh, I see. An order was passed. Oh.
Initially a remand made, then an order passed, which came to be challenged in a writ petition.
Yes, so what do you say about this? It is also not the case that the added petitioners had produced those documents before the adjudicating authority. Yes.
But it was documents lying with the respondent authorities, which they ought to, in spite of filing opposition, they did not disclose these. Now I got in possession of these documents and I wanted to produce this.
Which document specifically?
Yes, please come to, I just indicate the nature of documents. First is Form 4.2, the application made by the developer for sanction of plan. That's at page 32.
Yes.
It's from West Bengal Housing Board to the Municipal Commissioner. Not, West Bengal Housing Board used in opposition did not disclose this document. Please come to page 36 now. This is the document or application form on the basis whereof KMC has acted. This is 36.
Part of 32.
Blank. Part of 32.
Yes, it's a part of
32.
blank.
All blank. Now please come to the penultimate entry on that page 36. Registered power of attorney. This is what I wanted to disclose.
Yes.
My Lord Justice Mitra was putting this question to me as to these documents at serial number 16 and 19 at pages 36 and 37 respectively. Now, these were essentially documents which would be required for the purpose of adjudication.
Just give us one.
Yes.
Now, apropos of the observation which fell from the court in respect of pages 36 and 37, please come to running page 67. That's the opposition used by the board, West Bengal Housing Board.
67.
67. Paragraph 11 of page 67. I say that on 8 July 2009, the West Bengal Housing Board, the respondent number 7, executed a registered agreement by which the respondent number 8 was appointed as a developer and agent of the respondent number 7 and has been authorized inter alia to maintain, manage and develop the said land for implementation of a housing complex thereupon for LIG, MIG and HIG people with all other facilities therein and to sell or transfer the flats to the respective purchasers. 12. I say that as per notification, I'm sorry, I crave leave to refer to the registered agreement at the time of hearing if necessary.
But not the form.
Not the form.
Not the form.
That's page 37, 38.
So you wanted to place this
registered agreement. The document, that registered agreement, is at page 38.
Even if you don't use a supplementary evidence, you can argue as regards that.
But I wanted this page 38 to come on record.
Anything said about
if your lordship say today, give a letter to the learned advocate for the respondents, we allow you to argue on this document. Very good.
What you cannot do directly, you will do it.
Who's appearing for the housing board?
You are housing board. No.
I am for the Bengal peerless. I am for respondent number 7 in the writ petition. Respondent number 7 and 8.
Who is for the board? You have not served?
Yes.
7 is housing board, Mr. Mitra.
I was appearing for respondent number 7.
That's the housing board.
Respondent number 7. 7th respondent. Because number 8 is a joint venture of the peerless group and housing board.
SPV between.
SPV between. So I am really management of respondent number 8. Part of the management. West Bengal Housing Board.
Are you 7 or 8?
I am 7.
You're housing board.
I am housing board. Senior Mr. Mitra had appeared for respondent number 8 in the court below. I don't know whether he is.
How will you be prejudiced if this form is, other than the fact that you'll be on very soft ground?
No, not soft ground, Lordship. This is a matter of law, a matter of law. In fact, this is a matter of law. Matter of law. But in writ petition judgments, Jessup is writ petition judgment. Division bench of our High Court. This is Chakraborty's judgment is there in the writ court Shamiran Mondol's case. And there are several judgments. Lordship, one can't just bring on record like this is like amendment. How will we prejudice this?
It's not an amendment.
Bring on, there are many facts which are brought on as new. If you're making out a new case based, initially it was a case under the West Bengal Apartment Ownership Act. Now they want to develop a case on the basis of an agreement which they had entered into. That is not the case made out in the writ petition. That was. So, Lordship sees a supplementary affidavit and Lordship will see.
We have checked up.
No.
Respondent number 8 in the court below.
So now
Now I should be sure the same, Mr.
I'm representing the
Fearless.
Yes.
And now number I tell you, Lordship, what is the number of our client?
7 is housing board, 8 is fearless.
7 is housing board. Are you for board? Mr.
I am for the housing. Respondent number 7.
Then if when you have referred to that document in your opposition, what prejudice you will suffer, Mr. Mitro? That agreement which you have referred to in paragraph 11.
This is one of the documents. This is one of the many documents which they bring. Only a one part of it. This is only one fraction. And also gravely with my discussion whether to rely upon it. I have not disclosed it. I have only gravely.
Article 12 was
prejudicial facts can be there. Article 12 authority should be fair, etc. But then in a writ petition filed in the year
misrepresentation
2018, a new case made out which would otherwise become time barred.
Pages 21 to 32 of the writ petition all deal with misrepresentation and not this fraud, suppression of material facts. It starts from page 21. I'm submitting with responsibility. No new case has been made out.
No. That's what I wanted to ask. That Mr. Mitro, the finding here that a totally new case is being laid out by disclosure of these documents.
What it kindly sees the judgment which starts.
Let me just get
only one. That page 9 recording. There is no such order not available as uploaded. But we shall try to find out.
But there's a recording.
There's a recording, but there is no such uploaded order. We shall try to find out if there is.
Order to all three.
We need to apprise the Lordship of the stage at which this was filed, the conspectus of the proceeding in the previous round of litigation and the conspectus of the proceeding in the present round of litigation. They had, my lord, all the disputes available to them under the sun were available to them, my lord, in the first round. They filed a writ petition here saying that the corporation was not considering their representation. The representation was restricted only to section 397 of the KMC Act 1980. They allegedly had plethora of other grounds which they chose to urge in that writ petition. But my Lord Justice Tandon was pleased to dispose of.
Would be aggrieved if the facts come, whatever is the fact that will suppose today a decision is taken without considering a judgment. This would lead to multifarious proceedings, isn't it? Because this litigation will continue once more.
But then at what stage and who are these people? They are people who are stepping into, they are getting themselves added as added petitioners pursuant to a notice akin to Order 1 Rule 8. They come out here and say, my lord,
Substantive. Yes, Mr. Mujumdar, continue.
Pages 32 to 36 was that application and 38 was the agreement, which is referable to page 67 of the stay application being the pleading of the board. May I come back once again to the order under appeal at page 9. The case made out in the writ petition is that, I'm sorry. The case made out in the writ petition is that several deeds of conveyances were registered prior to the grant of sanction of phase 2. The date of registration of the first deed of conveyance was also stated therein to be on 18th August 2016. Whether registration of deeds in respect of flats in phase 1 prior to sanction of plan of phase 2 has any effect or not shall be considered at the appropriate stage, and neither the details of registration nor the total number of registration of deeds made prior to sanction of plan for phase 2
shall have any relevance for deciding the issue raised in the writ petition, and therefore, for such reason, the said list cannot be allowed to be brought on record at this stage. No, this was a list of conveyances entered into in the meantime. The delay in obtaining the screenshots of the documents available in the public domain has not been explained in the second affidavit.
What were those documents?
Now, please come to page 116.
Those are registration details.
No, screenshot.
One.
I just can't even see. So 116. Yes.
Those registration details starts from 103.
That starts from 103 to 115.
So those are the registration details. When it was.
Yes. Now, which the Honorable Single Judge feels that whether it was entered into prior to or before the commencement of phase 2, that shall be taken care of or it has no relevance. I'm sorry. Please come to 116.
No, will be taken care of. So it will be considered.
Yes. For deciding the issue as to whether it will have any relevance or not.
Yes.
But if the Honorable Judge, Single Judge feels that this has to be taken care of at a subsequent stage, it was required to be brought on record.
No, it's on record. Sorry, it's on record already.
Please see 116. Details of conveyance executed and registered in respect of flats in Abhidepta phase 1 prior to 11th January 2017, so far as could be ascertained by the applicant's added petitioner 2324. But this is the screenshot. Date of sanction of the building plan for phase 2. No, screenshot. I'm sorry, which is 117. I'm sorry, 117. Kindly pardon me. Now, this was a screenshot from the portal of West Bengal Housing Industry Regulatory Authority, WB HIRA, as it then existed. And this happened post filing of the writ petition, which will show the specification of land area and the total built up area. Please see the second column of that page.
117.
117. This is phase 2.
What's the second column that you have?
There are two encircled entries. One is land area, the other is total built up area.
Yes.
Almost at the middle portion of that page.
Floor area. Floor area. এটা না করে ওরা হচ্ছে আমাদের 3 acres টা আমাদের ওরা পুরোটা নিয়ে নিচ্ছে ইনক্লুডিং 3 acres এর 12 এর উপরে এফআইআরটা দিচ্ছে phase 2.
This will give the FAR, permissible FAR or applied for FAR.
68 is রেসপন্ড নাম্বার 67 টা তো অ্যাফিডেভিটের রেসপন্ড নাম্বার 8 তো রেসপন্ড নাম্বার 7 বলছিস কেন হাউজিং বোর্ডের অ্যাফিডেভিট নয় এটা
No.
Well, no, this affidavit which has been shown, page 67, 68 is not the housing board's affidavit.
It's not the.
It is not the housing board's affidavit. Which that's why Lordship asked me. I have no. This is not the housing. This is the Bengal PLS's affidavit. Respondent number 8's affidavit. Sir.
Oh, I'm sorry.
Mujumdar said it's the
number
housing
8.
board, not the housing board's affidavit.
Respondent number 8.
It is the SPV.
8 is PRS.
Yes. Of which housing board is one of the constituents.
Yes. Joint
Shareholder.
Joint sector.
Now, page 117 is an information uploaded on the website of HIRA as it then existed by the developer for phase 2.
এটাই হচ্ছে নিজের একটা পার্ট। 7 share আছে মানে major stake.
How much shares is Housing Board holding in at SPV?
I will check it. 49 না আমি জানি না কত পার্সেন্ট শেয়ার আছে almost 49.95%.
49.95. Housing Board এটাতে হোল্ড করছে 49.9. বেঙ্গল পিয়ার এটা হচ্ছে স্পেশাল পারপাস ভেহিকল এই কাজটা করবে। এটা আছে 49.5, বেঙ্গল পিয়ার এটা আছে 50.5.
Yes. Not coming back to the order, page 10. So the other ground is delay in obtaining the screenshots. But this happened only after the filing of writ petition, and not this is.
How do we get that, Mr. Majumdar? This you said this happened after the
Yes, not the
filing of the writ petition.
We want that to
So there was a pleading in the supplementary affidavit, but the document does not show, of course.
First.
Oh, but I am grateful to my learned friend. Please come to page 100. Paragraph 5. Respondent number 8 had registered phase 2 with a registration number so and so dated 8/2/2019. So writ petition was instituted in 2018.
Yes.
But coming back to not the order under challenge at page 10. That apart, the facts pleaded in the supplementary affidavits, if allowed to be brought on record, would ultimately result in enlarging the scope of writ petition, which is impermissible as this court has to exercise its power of judicial review of a decision taken by the authority of the KMC. This court further holds that the prayer of the added writ petitioner numbers 23 and 24 for leave to bring on record the documents by way of supplementary affidavit after commencement of hearing of the writ petition was only for the purpose of delaying the disposal of the writ petition. In so and so, the Honorable Supreme Court, after taking note of the provisions of Order 8, Rule 10, held that the court in its discretion would have the power to allow filing of written statement after expiry of the statutory period. The Honorable Supreme Court, however, clarified that the time can be extended only in exceptionally hard cases and not in a routine manner. In so and so, the Honorable Supreme Court held that if cogent reasons are assigned for not filing documents along with written statement, leave to produce the document subsequently can be allowed. However, in the said reported case, leave was sought for when the suit was posted for evidence, that is long prior to the stage of arguments. In so and so, the Honorable Supreme Court was dealing with the issue as to whether the entire appeal would abate or the appeal would abate only against the deceased, which is not the issue in this case. However, the Honorable Supreme Court in such and such cases was not called upon to decide whether a new case can be made out by filing a supplementary affidavit after commencement of the hearing of the writ petition. In view thereof, this court is of the considered view that the said reported decisions is of no assistance. For all the reasons as aforesaid, the prayer of the writ petitioner for leave to accept the supplementary affidavits is refused and supplementary affidavits affirmed and so stands rejected without, however, any order as to cost.
Where are those supplement?
Please come to page 23 first.
This is your first supplementary. What was the affirmation date?
But this was affirmed on 2nd of December 22, appearing at page 29.
And your second supplementary affidavit?
Begins at page 98. Rather, 98. The date of affirmation is 2nd January 23.
Yes.
Please come to page 28. Paragraph 3.
28.
28B. Numbered as
28B.
28 capital B.
Yes, paragraph 3.
Yes. But that's the 2017 RTI reply, which has been referred to. Photocopy of the reply was annexed, but which the Honorable Single Judge disallowed on the ground that it was made available to the original writ petitioner in 2017. He has not relied upon, so why are you relying upon this?
What is your answer?
But it's a document which is relevant for the purpose.
You adopted it petition case.
Why it is relevant, Mr. Majumdar?
Please come to the document once again.
Page 30.
32. I'm sorry, 2017 document is 30.
What was the information given? This was his application, no,
Yes.
from Deputy Chief Engineer.
Right. That's the reply. We see entry number 3. Filled up application form for sanction of building plan submitted by the applicant is enclosed. That's the West Bengal Housing Board's application in form.
Which you showed us to be blank. It was not blank, you said?
There are annexures which are there, copies of which they have not sought. That's there in the RTI reply. He has not placed the entire document. Well, let him finish, not we'll deal with it. RTI reply says he's
Why
not
don't
asked
you
for the
disclose it?
My
If
lord?
you have an answer to all of the documents, disclose it.
Those
If
documents.
you are covered, then why are you so scared of the documents being disclosed?
They try to create a completely new case bereft of 397. Like, kindly let him finish, not kindly give me 10 minutes. It's beyond the scope of 397 altogether. They have taken conveyances. Now, with their eyes wide open, they want to open up civil disputes in the lurch of 397.
You're eating into your 10 minutes.
My lords?
You're eating into your 10 minutes.
My lord, then I'll stop immediately.
Yes.
Then, however, in respect of annexures, query should be specific. NOC of relevant authority are available from the certified copy of building sanction plan. Then some, it's not very happily legible, is available from the certified copy of building sanction plan. Information regarding site plan, car parking calculation, FAR calculation are available from the certified copy of building sanction plan. Your query raised in serial number 5 is not specific, no information available. Not with these, then may I come back to 28B? Paragraph 5. Your petitioner very recently has obtained one agreement which is important for the purpose of adjudication of the writ petition. The said agreement was duly executed between the Housing Board and Bengal PRLS. That's between the respondent number 7 and 8. Which the respondent number 8 itself wanted to rely upon in course of the proceeding at page 67.
Agreement is page 71, na?
The agreement is 38, I believe. 32. The agreement.
Oh, this is part of it, right?
38, page 38.
Oh, 38. 71.
Correct.
Yes.
Now please come to the second supplementary affidavit at 98. But thus far, not in my most respectful submission, the first supplementary affidavit does not seek to alter or amend the writ petition. It's only a pleading in support of disclosure of document.
Just show us your prayers in the writ petition once.
Right. Please come to page 93. 93 of the writ petition. It's a writ petition has been separately filed. It's a thickish one.
কোথায় দিয়েছে?
Petition করে দাও।
From page 21 onwards, it's a case of misrepresentation and fraud made out. Okay.
Petition কোথায়? follow that.
If I may quickly take your lordship through the pleadings at paragraphs 22 and 22A at page 25.
Yes.
Your petitioner state and submit that the process of execution of the sale deeds for phase 1 commenced on and from 12th August 2016. And the sanction of the new plan was obtained on January 2017. Video so and so, dated so and so, and the FAR, ground coverage, etc., as well as other parameters have been calculated on the entire land of 12.27 acres, despite the fact that the ownership of 9.04 acres was transferred to the flat owners in phase 1. Your petitioner state that by considering the entire land of 12.27 acres for obtaining sanction of building for construction of phase 2 on the balance 3.23 acres of land, in this way, additional floor area has been sanctioned without paying heed to the rules and regulations. This is without any doubt misrepresentation and suppression of material facts.
Yes.
It goes on to deal with the various phases or the facets of an plan to be sanctioned by the KMC authorities, taking into consideration various factors. Now, please come to the prayers note which my Lord Justice Mitra wanted me to show at page 93. Grant leave under Rule 12 of the writ rules, then prayer B. Mandamus commanding KMC to rescind the order dated 15/1/2018. I'm sorry.
Yes.
So first is cancellation of the order of 15/1/2018, which was passed on remand by the KMC authorities. 2, to take appropriate measures under the Act and rules to prevent any further construction on the basis of building plan of 2017 at premises number so and so. 3, to inspect the premises corresponding to RS Dag number and a report and to submit a report with regard to unauthorized and illegal construction. 4, not to sell or transfer leave so and so corresponding Dag number so and so. 5, to take immediate effective steps against the private respondents and each one of them so that they cannot make any further construction in the manner whatsoever in the premises. That prohibition would definitely not apply. Then please see prayer D at page 97.
So you summarize your arguments now.
Lord, the Honorable Single Judge, while dealing with my 2 supplementary affidavits enclosing certain documents seeking leave to be rely upon, has probably proceeded on a basis that I was seeking amendment of the writ petition, or trying to make out a new case.
Yes.
This is not so. Secondly, a factual error crept in the process. Why so? At page 8 of the order under appeal, His Lordship proceeds on the basis that the writ petition did not make out a case of misrepresentation. This is the top of page 8.
Contrary to your pleadings.
Contrary to the pleadings.
Yes.
Thirdly, the Honorable Single Judge proceeded on the basis that this fact, this document could have been produced in the writ petition, with the writ petition. But not His Lordship probably did not take note of an interim order passed by the Honorable Court, wherein not an order in the nature of this rule, an order was passed in terms of Rule 12 of the writ rules. And I am applied in response to such order and advertisement having been made.
Why would the writ petitioners withhold those documents had it been in their possession?
But for some reason or the other, the writ petitioners, the board, the developer did not produce documents in their possession. I'm not, when these issues, please have a look at the impugned order in the writ petition first. The order impugned in the writ petition. It's at page 298 of the writ petition. Please come to 299. The first page deals with the recital of proceedings thus far. Straightway comes to page 299. But the third paragraph on that page, beginning with the words, the basic grievances of the writ petitioner as ventilated in the letter or representation dated 26 May 2017 are that.
299.
299 of the writ petition.
Where you are reading?
But the third paragraph of that page, beginning with the words, the basic grievances of the writ petitioner.
Yes.
As ventilated in the letter or representation dated 26 May 2017 are that the West Bengal Housing Board, Bengal Peerless Development Company Limited have obtained the sanction of a building plan for Project 2 on the basis of misrepresentation stating that the new project was to expand over the existing residential complex. The next paragraph. In terms of the order of the Honorable Court, the said representation was taken into consideration under section 397. The parties to the proceedings were given reasonable opportunities of being heard, and the parties exchanged their respective objections and rejoinder in connection with the said representation dated 26th May. Before dealing with the contentions or submissions of the respective parties, it is necessary to record certain facts on record in respect of the building as sanctioned, which are as follows. But I skip over that factual aspect. Straightway comes to 300.
So case made out of fraud and misrepresentation.
Yes. And that's the only ground on which a sanction can be challenged in terms of section 397 of the KMC Act.
Yes, Mr. Mitra.
Please come to 303.
303.
My lord.
How long will you take, Mr. Lord?
I beg your lordship's pardon.
How long will you take?
But I have almost concluded.
My lord has another.
Oh, yes, yes, at 4:15, or probably at 4 o'clock.
So, how long will you take?
I'll take a bit because I'll have to take your lordship into the. I'll have to take your lordship into a bit. It would appear that lord.
Won't be able to finish it today.
My lords.
You won't be able to finish it. My lord has
Yes.
different specs.
Yes, you conclude then.
Mr. Majumdar,
Please come to 303. Now, just after section 397 has been quoted, I read 397. If at any time after the commencement of sanction or provisional sanction to the erection of any building or the execution of any work, the municipal commissioner is satisfied that.
where are you?
I am reading not page 303, section 397 has been quoted.
Reading 397.
My lords. If at any time after the communication of sanction or provisional sanction to the erection of any building or the execution of any work, the municipal commissioner is satisfied that such sanction or provisional sanction was accorded in consequence of any material misrepresentation or any fraudulent statement in the notice given or information furnished under sections 393 or 394 or 395, he may by an order in writing cancel for reasons to be recorded such sanction or provisional sanction, and any building or any work commenced, erected or executed shall be deemed to have been commenced, erected or executed without such sanction and shall be dealt with under the provisions of this chapter. So a clear case of misrepresentation and sanction having been obtained in such manner was before the authority and was taken up in the writ petition. So it was not a new case which was sought to be made out at all through introduction of this supplementary affidavit and the documents annexed thereto. This was only an evidence or an exhibit.
Yes.
And the satisfaction of the municipal commissioner to be now substituted by the Honorable Court's views will relate back to the date of commencement of construction as statutorily laid down. Now please come to the last paragraph on that page. Indisputably, at the time of submitting the application for sanction under section 394, the private respondent had the exclusive right to erect on the land in question at the said premises. It however appears that during the process of consideration of the proposal for sanction of additional construction at the said premises under section 394 of KMC Act 1980, certain deeds of conveyances were executed in respect of certain numbers of flats of the building under the first sanction described as so and so. Though pending disposal of the application for addition made under section 394, deeds of conveyance is executed in respect of their respective flats. On a reading of the deeds of conveyance as a whole, it appears
So, Mr. Banerjee, we will give you leave to respond to those averments which have been made. If it is not that we are closing the case, your contention will be taken.
What he's done is something which he couldn't have done by way of amendment. I'll show you, lordship. But kindly bear with me for a bit. I'll show you, lordship.
So you take that defense in your opposition. Finished.
Whenever an amendment is allowed, lord, additional legal statement is allowed to be filed. He comes up with an application for amendment in the form of supplementary affidavits at the final hearing stage when already hearing is concluded.
Mr. Banerjee, from what we have understood, Mr. Majumdar says not a single word of pleading. We'll disclose 4 or 5 documents and that's it. So you deal with those documents. We'll give you that liberty. Both of you, both Housing Board and you, to deal with those documents.
My lords, I bow down to your lordship, lord. I wouldn't have, my lord, stood in the way, but this is a case in which these additional writ petitioners have come in and tried to open a box which they had closed earlier.
We will specify that the contents of the supplementary evidence.
Ordinarily, whenever my lords will permit anything like this, my lords will keep merits open so that it goes back, all points kept open. I'm aware of that. I would still like to show that, Lord, this attempt by them at this belated stage is for collateral purposes. It's for the purposes of open up things that they have given up. Lord, after he finishes, please, my lords, give me some time to trace back the slight history of the proceeding. This is the second round of litigation. He has consciously abandoned and or not claimed certain rights which he could have. He's been hit by explanation 5 of section 11, and that applies squarely in writ proceedings. In round 2, at the fag end of arguments, he comes up with documents.
Finish of this is your argument.
No, I'm not. Please come to the last sentence of page 394. Last paragraph. 304. Thus, the penultimate paragraph, thus, even on the date of grant of the plan for addition under section 394 of the KMC Act, the private respondent stroke developer continued and still continues to have the exclusive right to erect on the land. In view of the terms and conditions of the conveyance deed as agreed upon by the parties, the writ petitioners, being flat owners of the building constructed under the first sanction, cannot raise objection about the construction of the multi-storied building on the open land. In fact, the second sanction has been granted for construction of the building on the south or northwest side of phase 1. The board retain its exclusive right to make further construction on the said open land at the premises in question, and the writ petitioners and the other flat owners admitted such exclusive right of the West Bengal Housing Board while purchasing respective flats under conveyance deeds. It has already been stated that at the time of submission of the proposal or the application for obtaining second sanction, no conveyance deed was executed in favor of any flat owner. So this was the agreement between Housing Board and the peerless. So this was a document which was taken into consideration by the authority. The West Bengal Housing Board and the private respondent at the time of execution of the conveyance deed expressed their minds in clear terms to the flat owners that there are scope for further construction on the remaining vacant land. So the authority itself has relied upon that agreement, and this was not before the Honorable High Court. At the said premises, and right to construct shall remain with the West Bengal Housing Board and the private respondent, but not to any others, and the petitioners accepted such terms with their eyes wide open, and hence the flat owners cannot raise any objection while exercising such right by the West Bengal Housing Board. The writ petitioners have now sought to urge that the private respondent are not entitled to make construction on the remaining vacant land by utilizing the FAR of the entire land, when the right to make further construction was reserved by executing the conveyance deed. With the said terms and conditions, it was explicitly understood by both the parties to the conveyance deed that the entire area of the land in the said premises would be taken into consideration for the purpose of calculating the FAR in the matter of grant of sanction for addition of the to the existing building, which is described as phase 2.
Sanction in question is according to consonants. In consequence, I am not at all satisfied. It is not called important, but please go on. To that order have you annexed?
Not annexed, but it's available, not that
Or
order.
it is not available?
It's available, not.
Available.
But not that order is not available, or it's not uploaded. Page 9.
But strangely, that order, the date is also not provided.
Not provided.
It's just single bench, while referring to the earlier order by which another single bench had disallowed them to make additional statements and pleadings, refers to an order. But there is no date of the order given, and hence it's not even traceable which orders my lord has been referring to.
It will be on the website of the reference.
In the order.
In the order, page 9.
Yes, page 9 of the
Date is not given. Date is not.
The writ file may have a copy because printouts are generally kept in the writ file in the original side, the upper file.
Really? So glad you told us. We would know otherwise.
Yes.
Not summing up, not page 307, a case of misrepresentation was being dealt by the municipal commissioner, and we challenge this on the ground of misrepresentation. And these documents are relevant because the self-same documents find reference in the order impugned in the writ petition. Today I am not troubling your lordships with the merit of the decision. That is before the honorable single judge. We are only on the propriety of the order, apropos our right to use these documents as materials.
All right. Yes, tell us how long will you take and fix it, because we have to fix the bench according Mr. Mitro.
No, sure, next week, because today, anyways, this has come suddenly, so I told him he has to handle today. Lordship, next week, any day, I am, or any day thereafter.
Ashok, we have heard Mr. Mojumdar done.
Manoj was asking a question, putting a question to me.
Well, not, well, the 26th, 25th or 27th, because the 26th at 2 p.m. have a matter fixed, well.
We are keeping it at 3 p.m.
3 p.m. just in case, what you, if it, Mr. Banerjee is of course there.
Let him finish, and you finish off your case and come over. Twenty-sixth করেছো তো 27th ওই মামলাটা ফিক্স করা আছে
অ্যাসাইনমেন্ট নেই এটা অ্যাসাইনমেন্ট
আচ্ছা ওটা চেক করে নিও হ্যাঁ
সাইন
let the affidavits exchanged by the parties as filed
chart of the documents not apropos the statements not with the page numbers as relied upon. This may be of some assistance if it.
Yes, keep it. Give it.
Reference in the writ petition. The documents as referred.
শোনা এটা একটু সাজিয়ে দিও না রিট পিটিশন
about your locus.
Lucas.
Lordship has lines
Yes,
keep in mind.
Yes.
Just indicates the Division based.
I said, I know the answer, but I was just wondering to what extent,
I was thinking of the same thing.
কল করে দাও, কল করে দাও। 2 নম্বরটা কল করে দাও, কি আছে? This is the matter you were mentioning. Oh, you are for KMC.
No, my lord.
তাহলে KMC
So this is
where is Mr.
that's OD1, my lord. OD1 was Shengupta was there, my lord.
In the oh, you are in 2.
No,
What happened?
OD2, my lord, this is my appeal, my lord, arising out of an order whereby, my lord, my petition has been dismissed. My lord, the factual aspect, but before I go into it, my lord, a resolution plan was approved.
No,
And my
Mr.
lord,
Ghosh, have you given notice to your other side?
My lord, they had appeared earlier as well. But my lord, I'll also just indicate, my lord, if we can come back on another day, I'm led by Mr. Banerjee. He has expressed some personal difficulty.
Which Banerjee?
Mr. Ratnanko Banerjee.
As you say, should I just assume?
I'm sorry.
Personal difficulty.
I believe your lordship.
You have to tell the court.
Lord, I believe
Yeah.
yes, we'll do that.
Or were you thinking something else?
No. For your lordship, lord.
No. If it's a difficulty, you ask Mr. Dan.
Very well, my lord.
What is it? What is he?
The difficulty, I believe your lordship understands. Lord, there's also one thing which I should point out. My lord, the successful, the corporate debtor, my lord, of, my lord, was Ram Sarup Industries.
Then why aren't you saying?
No, my lord, because I needed to indicate to this, I needed to indicate this.
You weren't indicating it. No,
তাহলে একটু লিখে নি on number 2 তে ওনার appears on personal ground of one of us বলে জজ সাহেবের নাম দিয়ে দাও, comma the matter stands Mr. We are keeping it in. Mr. Mojumdar has left.
No, he's there.
No, we are keeping it because that week we have fixed matters. So we will we will keep it on 10th April. 10th April করে দেবেন ডেটটা। 10th April at 3 PM. নতুন বেঞ্চ
কিরকম দেখতে
Call করে দেবো।
বেরোতেই হবে সাপ্লিমেন্টারি লিস্ট বেরিয়েছে
এটা তো ওয়েবসাইটে
ওটা বেরোতে এক সেকেন্ডের জন্য
Where were you?
My lord,
Mr. Panja was
yes, no, I was my lord, just immediately I came and then, my lord, I rushed to another court and then came back, my lord, I'm very sorry.
He had to come from his chamber.
No, I tell you, because my court officer says, my lord, the senior has to present, that's why, my lord.
No, because Mr. Panja was there.
Yes.
So, but he was having some health issues.
That I know, my lord, that I know. That I know, my lord, since the, my lord.
Alright. Thank you.